Yang Berbahagia Datuk Ahmad Teriruddin bin Muhammad Saleh, Yang Barusaha Tuan Zamri bin Nisman, distinguished guests, ladies and gentlemen, a very good morning. Allow me to virtually welcome everyone to this KL webinar themed Access to Justice and Professional Responsibility, Global Perspectives on Third-Party Funding. I am Bhavini Singh and I will be your MC for today's conference. This KL webinar aims to gather global perspectives towards regulating third-party funding in light of the growing consensus for transparency and professional responsibility in this funding industry. We are privileged to have a fantastic lineup of moderators, speakers, and specially curated sessions to provide valuable insights on the subject matter. We would also like to take this opportunity to acknowledge and thank our collaborating partner, the Legal Affairs Division of the Prime Minister's Department, Malaysia, and our supporting organizations, the Inns of Court Malaysia, the Malaysian Institute of Arbitrators, the Chartered Institute of Arbitrators Malaysia branch, and the Borneo International Center for Arbitration and Mediation for your commitment and support. To formally start our conference, we would like to invite Yang Barusaha Tuan Zamri bin Nisman, Director General of the Legal Affairs Division of the Prime Minister's Department, Malaysia, to deliver the opening remarks. Let us all give Yang Barusaha Tuan Zamri bin Nisman a virtual round of applause.
A very good morning and a warm welcome to the esteemed attendees. It gives me great pleasure and profound sense of honor to deliver the opening remark for the KL webinar, Access to Justice and Professional Responsibility, Global Perspective on Third-Party Funding. This momentous event has been organized by the ASEAN International Arbitration Centre Malaysia, AIAC, in partnership with the Legal Affairs Division of the Prime Minister's Department, Malaysia. Indeed, the KL webinar served as a step in the Malaysian government board's effort to position Malaysia as a preferred arbitration hub. Aligned with this objective, a task force has been constituted to streamline our Arbitration Act to reflect the evolving landscape of the international arbitration. As arbitration continues to evolve globally, we have today found ourselves at a pivotal juncture in the legislative landscape of Malaysia. In keeping close traction with the growing recognition of third-party funding in international arbitration, the Government of Malaysia intends to introduce a regulatory framework to govern third-party funding, encompassing provision legalizing third-party funding and promoting professional ethics and responsibility among the funders. Such measures are imperative to foster an environment where third-party funding is characterized by fairness, transparency, and reasonableness. Distinguished guests, ladies and gentlemen, in the Malaysian legal system, the concept of maintenance and champerty are embedded in the Civil Law Act of 1956, which allows the application of common law, rule of equity, and certain statutes. Even the Malaysian Contracts Act poses challenges to the introduction or legalization of third-party funding. While a third-party funding arrangement is seemingly straightforward contract between a third-party funder and the party receiving the funding arrangement entail a variety of implications that permit various facets of legal proceeding. Although TPF broadens access to justice, it has the potential to enhance visitors' claims. Disclosure of third-party funding is another growing concern, as non-disclosure may lead to a conflict of interest and ultimately adversely affect the legality of the arbitral award. A larger concern revolves around the extent of control funder may exercise over the claim and the conduct of the arbitration proceeding. Ethical considerations loom large, as financial imperatives may be the sole driving factors influencing decision making. This concern underscores the importance of establishing a sound framework to fully realize the advantages of third-party funding while safeguarding against the potential risks. Keeping in mind all these aspects, Malaysia endeavour to enact a regulatory framework that reconcile the imperative of third-party funding with the principle of fairness, justice, and transparency. Distinguished guests, ladies and gentlemen, we are delighted to be hosting this webinar by the presence of distinguished luminaries from across the globe who will enlighten us with their insights and experiences. Our sincere appreciation to the speakers and moderators for agreeing to contribute their invaluable expertise and knowledge. We seek to deepen our collective understanding of the opportunities and challenges inherent in introducing third-party funding to arbitration and related proceeding through this dialogue and exchange of ideas. With this, I wish each of you a fruitful and productive session. Thank you and wish you all a pleasant day.
Thank you, Young Berusaha Tuan Zamri bin Misman. Ladies and gentlemen, let us now welcome Yang Berbahagia Datuk Ahmad Teriruddin bin Muhammad Saleh, Chairman of the AIAC Board of Directors, for the keynote address.
Assalamualaikum warahmatullahi wabarakatuh. Yang Berusaha Tuan Zamri bin Misman, Director General of the Legal Affairs Division of the Prime Minister Department, Malaysia, esteemed speakers and moderators, distinguished guests, ladies and gentlemen, a very good morning. First and foremost, I would like to begin my speech by extending my appreciation to the organizers, the Legal Affairs Division of the Prime Minister Department and the ASEAN International Arbitration Centre, Malaysia, AIAC, for extending this gracious invitation. It's truly a privilege for me to stand before you as I deliver the keynote address of this significant event. I now turn to extend my warm welcome to each of you. Today, as we dive into a trending topics entitled Access to Justice, Professional Responsibilities, Global Perspective on Third-Party Funding, our focus will be on the intersection of legal ethics, professional responsibilities, and the broader goals of ensuring access to justice in the context of third-party funding, TPF, in litigation and arbitration. Distinguished guests, ladies and gentlemen, as many of you are aware, TPF serves as a strategic investment in the resolution of dispute. Essentially, TPF transpires when an entity that is not a contracting party provides funding to one of the parties involved in a dispute. In return, if the claim is successful, the third-party funder will be reimbursed in accordance with the funding agreement. Across various common law jurisdictions worldwide, such as Singapore, Hong Kong, and the United Kingdom, TPF has gained widespread recognition and the legal acceptance predominantly in litigation and arbitration, subject to certain limitations. Notably, these jurisdictions have opted to legalize TPF for specific types of proceeding, deviating from the traditional doctrines of maintenance and jeopardy. The most recent and significant milestone in this regard was reached in Nigeria, where TPF was explicitly allowed through an amendment to the Arbitration Act in May 2023. Interestingly, in several jurisdictions such as Italy, Switzerland, Mainland China, Japan, and South Korea, the position of TPF as it stands remain neither prohibited nor expressly regulated. The absence of explicit regulation poses unique challenges and uncertainties for parties seeking to engage in TPF arrangement within this jurisdiction. At this juncture, it is also worth noting that TPF is permitted in certain states of Australia, including New South Wales, South Australia, Victoria, and the Australian Capital Territory. On the other hand, the doctrine of maintenance and champathy still holds sway in other parts of the country, specifically in Queensland, Western Australia, Tasmania, and the Northern Territory. The legality and regulations of TPF remain subject to the constraint of these traditional doctrines. Distinguished guests, ladies and gentlemen, insofar as the Malaysian legal landscape is concerned, the concept of TPF remains a relatively uncharted territory, unlike other jurisdictions such as the United States, England, and Australia, where TPF has grown into a multi-billion-dollar industry. Malaysia has yet to embrace the full potential of this industry. Currently, TPF agreements are void under Malaysian law. This reflects the country's cautious approach towards the form of litigations. However, amidst this legal ambiguity, there is also a growing recognition among the policymakers and legal practitioners of the need to modernize Malaysian approach to dispute resolutions and access to justice. In this context, the notion of integrity holds particular significance. The Minister in the Prime Minister's Department, Law and Judicial Reform, Datuk Sri Azalina Osman Said, recently announced a consensus between the Malaysian government and the European Union counterparts regarding the regulation of TPF, underscoring the needs for heightened attention to TPF. This signals Malaysia's resolute commitment to engaging in this discussion that shape the future of dispute resolution and broaden access to justice. By embracing this potential and ensuring a balanced regulatory framework is drafted, Malaysia too can pave its way for a more inclusive and equitable legal environment, empowering individuals and entities to seek redress while upholding the integrity of the legal processes. The liberalization of TPF marks a significant shift in the legal landscape worldwide as it increases access to justice for those who are unable to afford the cost of litigation or arbitration without TPF. The legal proceeding may prejudice the financially incapable and underprivileged parties, either through the process or the outcome. Under these circumstances, TPF steps into the bridge the gap by absorbing the cost of legal proceeding in exchange for compensation if funded cases emerge successful. Moreover, TPF also serves to strengthen the equality of arms between the parties to legal proceeding. It seeks to balance the scale of justice with the wealthier counterparties, thereby promoting fairness and equity in legal proceeding. Therefore, the parties will be able to focus on the merits of the case rather than the cost of funding it. As the famous quote goes, with great powers comes with great responsibilities. Amidst the promising aspect of TPF, we must acknowledge that these inherent challenges and concerns that serve as barrier. Distinguished guests, ladies and gentlemen, one of the major concerns for liberalizing TPF is the potential rise in vexatious and frivolous claims initiated by a funded party, given that the risks and costs of a funded parties are mitigated. This phenomenon is termed as a moral hazard, and it poses a significant challenge since parties involved in dispute are incentivized to pursue claims they might not otherwise consider without funding. Another major criticism faced is the under-compensation of the funded party. The pre-agreed compulsory agreement through the waterfall provision in a funded agreement often restrain the funded parties from renegotiating the funded's priority and percentage to the compensation upon the issuance of the awards. Often than not, the funded parties are left with a minimal portion of the pecuniary award and, unfortunately, may not even suffice to compensate their losses. Therefore, the absence of clarity and regulation on this aspect may expose the vulnerable funded parties to exploitation and manipulation by the funders constantly eyeing to maximize the profit gain from each funded case. These circumstances warrant specific regulatory measures to safeguard vulnerable parties while TPF is being liberalized. I will not delve too much into these topics, as I understand that there is an esteemed panel of speakers to discuss this topic in greater details. Distinguished guests, ladies and gentlemen, having said that, it is apparent that TPF has become an integral part of the investment arbitration landscape. Despite facing scrutiny in certain quarters, tribunal and national arbitral bodies have consistently leaned towards the view that TPF promotes access to justice rather than fostering frivolous claims. As we ponder the significance of TPF in our legal framework, let us not forget the faces and stories behind each case, real people seeking resolution, closure, and fairness. Moving forward, it is imperative that this effort to regulate TPF are accomplished with a receptive mindset to uphold our shared values of justice and integrity. As we strive to strike a delicate balance between harnessing the benefit of TPF and safeguarding the integrity of our system, let us remain guided by a sense of purpose and a genuine desire to serve the greater good. In this journey towards recognizing and regulating TPF, collaboration and dialogue will be our greatest asset. Before I conclude, let's remember that behind every legal decision and regulatory framework lies the potential to shape life uphold rights, and foster an equitable society. Together, we will strive to realize this vision. On these notes, I wish you all an insightful day. Thank you very much.
Thank you, Yang Berbahagia Datuk Ahmad Teriruddin, for the insightful keynote address. On that note, we shall now proceed to our first session, titled Third-Party Funding, Liberalization of the Maintenance and Champathy Doctrine and the Challenges Ahead. Session 1 will run for 1 hour, followed by a 15 minutes question and answer session. Should participants have any questions for the panel during the session, please place them in the question and answers box. This session aims to, first, examine the background and history of the Maintenance and Champathy Doctrine. Second, to explore the approaches taken to liberalize the doctrine in various jurisdictions. And third, to discuss the challenges encountered in attempting to liberalize the doctrine. The moderator for this session is Mr. Alvaro Lopez de Argumedo, partner at Uria Menendez. Mr. Alvaro focuses his practice on international arbitration and mediation, as well as on domestic and international civil litigation. He has vast experience in the recognition of foreign judgments and arbitration awards and seeking interim measures in support of arbitration. He regularly represents clients in national and international arbitration proceedings. Mr. Alvaro is an arbitrator at the Madrid Arbitration Court, the Madrid Bar Association Arbitration Court, the Spanish Court of Arbitration, CIMA, the Inter-American Commercial Arbitration Commission, and the Center of Arbitration of the Lima Chamber of Commerce. He is currently court member of the LCIA and president of the steering committee of the Union Internacional des Avocats Arbitration Commission. Mr. Alvaro shall be joined by our esteemed panel comprising Professor Victoria Shannon Sahani, Professor of Law at Boston University School of Law and member of the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration, Ms. Kim Rooney, Chair for the Hong Kong Law Reform Commission's Subcommittee on Third-Party Funding for Arbitration, and Dato Nitin Nadkarni, Consultant at Lee Hishamuddin, Allen and Glenhill. Let us give them all a virtual round of applause.
Good morning to everyone. I would like to start by thanking the Legal Affairs Division of the Prime Minister's Division of Law and Justice, and also the Asian International Arbitration Center for giving me the opportunity to moderate this excellent panel. Before going into the questions that I will ask to our excellent speakers, I would like to just mention three key issues about third-party funding. First, third-party funding is a growing and emerging industry in the international arbitration sector. According to the last survey of Global Arbitration Review 100, there were an average of 196 funded arbitrations per year between 2019 and 2023, and there were 208 funded arbitrations in 2023. And also the number of firms reporting funded arbitrations has also increased from 54 in 2019 to 72 in 2023. Second key issue, there are two primary factors which are driving this industry. First, the global financial market is seeking new forms of investments, and the high cost of international arbitration are determining claimants to try to share the cost of international arbitration. And third, different jurisdictions are taking different approaches to the regulation of third-party funding, including ethical rules that must be taken into account. We are going to discuss these issues with our excellent speakers that have been already introduced. So I will directly go to the questions I would like to ask to our speakers. We will follow the format of questions and answers. And my first question to our speakers is the following. And I will address this first to Dato' Nitin. Could you please provide us with an introduction of how your respective jurisdiction approaches the doctrines of champati and maintenance, and whether, in general, third-party funding is regulated in your jurisdictions? So I give the floor to.
Good morning, everyone, and thank you all for joining into this session. Well, yes, champati and maintenance are still relevant in Malaysia. Therefore, third-party funding is still illegal in Malaysia pursuant to Section 24E of the Contracts Act. It would require fresh legislation to overcome this problem. And there has been a discussion of this for many years, but there have been a number of objections to it. And I think the objections are as old as the doctrines themselves. Just to refresh everyone's memory, why do we ban this? And there's two quotes, one by Justice Darling in a case Rias Solicitor in 1912, where he said it's forbidden, champati is forbidden because it leads to speculative litigation and the harassing of people who ought to feel secure in their rights for the benefit of lawyers and other speculative parties. And another is a quote by Lord Denning in the 1960s, where he says that it's forbidden because it may result in improperly stirring up litigation and strife by giving aid to one party to bring or defend a claim without just cause or excuse, may lead to abuses, that the champatious maintainer may be tempted for his own personal gain to inflame the damages, to suppress evidence, or even to suborn witnesses. And for those who think this is all outdated claptrap, we only have to look at the Sulu claimant's case to realize exactly what can happen, that all of these problems still exist, that there still can be funding of speculative claims, inflaming of damages, whether there has been suppressing of evidence, I won't get into. So the real issue is the financialization of justice, as the trade justice movement in the UK described it, that you would result in these kinds of problems. Do you really trust fund managers who we know from the last 25 years of experience have very flexible ethics, if we can term it that way, to be involved in what should be, if not a cloistered virtue, justice? Lord Atkins said it wasn't a cloistered virtue, but at least there should be some separation from the predations of what Gavin Griffiths in the Santa Lucia case called, what did he call them? Mercantilist adventurers. So this is the objections that have been raised for a considerable period of time in Malaysia. However, I think there is a reality that we have to accept, that the world has legalized third-party funding. Malaysia is not a giant country like the United States or China that can stand in the way and block third-party funding. It exists. And we as a country have two choices, and all of our competitors, Singapore, Hong Kong, other arbitration centers are moving in the direction of allowing it. So Malaysia has two choices. We either try and create some sort of autarky where we fall out of line with the rest of the world, out of step. We are at a competitive disadvantage. That won't stop third-party funding, even in Malaysia. It just means that it will exist in an unregulated void. And to me, the worst of all situations is if third-party funding continues without any regulation, without any controls, and basically all of the problems that we saw in the Sulu claimants case will continue to exist in Malaysia. As to what regulations they should be, I defer to the two other panelists who have considerably more experience in this. Thank you.
Thanks, Dr. Nitin. So, okay, please go ahead, Kim.
Oh, thank you very much. And first, may I express my gratitude and appreciation to the organisers of this workshop and to our moderator and co-panelists. And thank you for giving me the chance to discuss what to me is an important topic in the world of arbitration, as it is the intersection between access to justice and commercialisation of law, as we've just been hearing. So what I've been asked to do in a few minutes is to share with you the approach that we took in Hong Kong, where very similar, and I'm just putting my timer on, which is why I'm looking like this, very similar concerns were expressed before the reform process started. And I think I've been invited to share the Hong Kong experience with you because I chaired the Law Reform Commission subcommittee that actually reviewed the law in Hong Kong. Our mission from 2013 to 2016 conducted a public consultation and also made recommendations and helped draft the legislation that implemented the reforms and the code of practice. So that's a long way of getting to what did we do in Hong Kong. Our terms of reference were to review the current position relating to third-party funding for arbitration for the purposes of considering whether reform is needed, and if so, to make such recommendations for reform as appropriate. And so, as I've mentioned quickly, we first reviewed this approach of other jurisdictions around the world, some of which have already been outlined. And then we drafted some draft recommendations, which we set out in a consultation paper and invited public responses. We actually received 73 in between 2015, early 26, from lawyers, arbitrators, third-party funders, pro bono groups, law societies, a whole range. And actually the overwhelming majority were in favour of reforming the law, provided there were appropriate ethical and financial safeguards. And the scope of the reforms that we'd been asked to review were all under the arbitration ordinance. So they could only be relating to arbitration under the arbitration ordinance, emergency arbitrator proceedings, mediation under that ordinance, and litigation under that ordinance, which is our Arbitration Act, based on the UNCITRAL model law. It was thought a step too far to review the waiving or the non-application of these principles to general litigation and mediation. We published the final report and our recommendations were adopted, but can I just say why it was said these reforms were needed? That they were to make it clear, because we had some uncertainty due to previous cases where the third-party funding of arbitration was allowed, to make it clear that third-party funding of arbitration and associated proceedings under the arbitration ordinance is permitted under Hong Kong law. And this is a big proviso, provided that appropriate financial and ethical safeguards are complied with. And we recommended that these were in the interest of arbitration users, the Hong Kong public, consistent with principles our apex had articulated, and that has been mentioned already, that a party with a good case in law should not be deprived of the financial support it needs to pursue that case, provided there are appropriate safeguards. And these financial and ethical safeguards are set out in a code of practice now, which is applicable to all third-party funders wherever they're based. And they provide the framework that they have to operate under. So just to finish that story in terms of the process, the implementing legislation was passed in June 2017. It only came fully into effect in February 2019. Why was that delay? Because there'd been an effort to encourage the mediation community generally to embrace third-party funding for mediation, not under the arbitration ordinance, but they said no. So in the end, the reforms were implemented strictly for proceedings under the arbitration ordinance, the Act, and with the code of practice for third-party funding for arbitration providing the framework. Now, I don't know at this stage if that's enough, Alvaro, because I think do you want me to expand, or is that sufficient for right now?
Well, I think it is sufficient for the moment. Many thanks, Ian.
Thank
you. So I would like to give the floor to Victoria so she can explain to us how this matter is regulated in the US. Many thanks, Victoria.
Thank you, Alvaro, and thank you to everyone for joining us. I appreciate you inviting me to speak on this panel, and really appreciate our distinguished moderator and co-panelists, and thanks to the organizers as well. So if I could sum up the law in the United States in one word, that word would be patchwork. So like a patchwork quilt or a patchwork blanket. The idea being that the states are all over the map, literally and figuratively. And so determining what you can and cannot do with respect to litigation funding or third-party funding in different states is actually very difficult. The landscape is constantly changing. And at this time, the majority of states in the US, it's a rapidly decreasing majority, but the majority of the states actually have no regulation of third-party funding. In addition, we have no federal regulation of third-party funding. So as everyone knows, the United States is a federal system. We have an overarching federal government, and then we have individual state governments, and those are joint overlapping regulators. So the federal government at this time has not regulated third-party funding, but they are aware of it and they are interested in it. So recently, the Federal Government Accountability Office, which we call the GAO, released a report on third-party funding in late fall of 2022, I believe, that signaled that federal regulation might be on the horizon. It basically gave an overview of the industry and talked about some potential avenues for regulation, but did not propose any regulation. There have been a few scattered bills in Congress that have been introduced, but nothing has been voted on. So just to give you a flavor of the range of types of responses for states that actually have regulated third-party funding or said something about third-party funding, I'll just give you a few. So funding regulation in the United States shows up in a variety of different forms. So you can have traditional state statutory regulation. You can have court rules that are issued by a particular court for parties who are appearing in court. And you can also have court opinions that come out by usually the state Supreme Court that say, throughout this state, here's the law of the land. You also have state attorney bars or licensing organizations that are also issuing ethics rules as to how attorneys should encounter funding. All of these things are regulatory influences on the funding industry. So when I say regulation in the US, I'm talking about all of these things broadly, okay? So just to give you a flavor of a few, The state of Indiana, Vermont, and Nebraska all actually have statutes on the books. They allow third-party funding and extend the attorney-client privilege to communications with funders, and this is unique. So there's a big question about evidentiary privileges and whether funding is covered. So that's one example. Delaware and Illinois have a lot of case law that says that funding agreements are protected by what we call in the US work product protection, meaning attorney work product is protected under privileges. So those are some examples. There's a few places where third-party funding must be disclosed. So Wisconsin, in all cases in that state, funding must be disclosed. In West Virginia, funding must be disclosed in consumer cases only. And in the Northern District of California, which is just a federal court, that court has adopted a court rule saying all funding in cases filed before the Northern District of California court must be disclosed. So that just gives you a few flavor of examples of what's going on in the US. Again, totally a patchwork, and the regulations are ever changing. So thank you very much.
Many thanks, Victoria. That's very helpful. So our second question for our speakers is regarding the basic ethical rules that should be taken into account. And specifically, the question is, if we were to regulate third-party funding, what are the basic ethical rules or provisions that should be included? I think this is one of the hottest topics in this field, and I would like to invite first team to provide views on this topic. Thank you very much.
Thank you so much, Alvaro. And as I mentioned, in Hong Kong, when we consulted the public about the proposed reforms to the laws, one of the areas was what ethical and aligned with them financial controls or safeguards there should be, and we received a lot of responses on that. And there was a consensus that it is essential to have these ethical and financial safeguards to safeguard against abuse of the process. And so what I am going to do, if I may, is share with you the approach we took in Hong Kong by the Code of Practice for third-party funders, for arbitrators, for funding, which applies to all funders. What did we cover? What standards and practices are they ordinarily expected to comply with in carrying on activities in connection with third-party funding of arbitration in Hong Kong, whether the arbitration is seated in Hong Kong or it's work being done in Hong Kong on arbitrations seated outside. So first, informed consent of the funded party. Essential that the funder informs the person they want to fund before the funding agreement is concluded as to the terms of the funding, and that they provide promotional materials, that they urge them to get in writing to suggest they get independent legal advice, and that they ensure that they provide a Hong Kong address for service. May I mention this? It may seem very minor point, but one of the issues that can arise if there's a dispute and there's between the funded party and the funder is, how does a funded party sue the funder if they're outside the jurisdiction, in our case, Hong Kong? And that's why we said there really needs to be an address for service in Hong Kong to remove that potential delay and obstacle. And we also in Hong Kong have an advisory body, so the funder, which monitors the operation of third-party funding associated with the Department of Justice. And so it is mandatory for the funder to provide the details of that advisory body to the funded party. Now, maybe this may stray outside ethical to financial, but we also thought it was critically important that it be clear to the funder they must have sufficient capital, and not just in their paid up capital, but they had to maintain the capacity to pay all debts when they become due and payable, that they cover all aggregate funding liabilities under all funding agreements for a minimum of 36 months. They maintain access to a minimum of just over US 2.5 million in capital, and they have ongoing disclosure obligations as to their financial situation. They're moving on, which a couple of speakers have mentioned already. The funder must have a clear procedures for management of conflicts and maintain them, and not and a control point that's come up already, not take any steps that cause or may cause the funded party's legal representative to act in breach of their professional duties. And aligned with that, that the funded party retains control. Now, may I just comment on that? When we reviewed laws in different countries, some countries were more inclined to say, look, the funder's paying, so it's reasonable they should have some degree of control over the arbitration. Whereas in other jurisdictions, the approach was more, no, this remains the funded party's case. They should retain control. We in Hong Kong opted for the funded party retaining control. It's also in our statute that there must be mandatory disclosure, that there is mandatory disclosure of third-party funding by the funded party to the arbitrator and to the other party. But the funder has a duty to remind the funded party of their obligation to make that disclosure. We also suggested, or it's not just suggested, it said that the funding agreement should state to what extent the funder is liable for costs, for example, adverse party costs, third costs, security for costs, and there must be grounds of termination of third-party funding that enables the funded party as well as the funder to terminate, because we observed in a code of conduct in another jurisdiction, it had only given the funder the power to terminate or the right, not the funded party. And also provision for complaints and enforcement procedures, provision for annual returns to the advisory body, provisions for confidentiality, and provisions for extraterritorial application. So may I say some of these were inspired by codes in 2014 in another jurisdiction, but we materially added to them and expanded the obligations of the funder. Thank you.
Many thanks, Kim. Very interesting. So I would like to give the floor to Dato' Nitin now in this regard.
Thank you very much. Okay, as I say, we don't have third-party funding regulations here, so I can't say anything about what actually there's nothing happening. But it seems to me the risks remain those identified by Denning, that there is a risk of frivolous litigation, inflaming damages, suppression of evidence, or suborning witnesses. So to me, the key ethics are not so much between the funder and the funded party, but rather regulating what has to be disclosed to the unfunded party and to the tribunal. So there's a number of problems. One is, of course, there's a risk of touting. You don't want lawyers to become touts for third-party funders or to gain secret commissions from third-party funders. You need regulations to prevent that. You need regulations to prevent lawyers having too close a relationship with any one funder. If a particular funder accounts for 30, 40, 50% of a lawyer's income, there's a danger that his perceived duty to his funder, his paymaster, may override his duty to the court or the tribunal, and may override the strict rules of etiquette. Should funders be bound by the same rules of etiquette that apply to lawyers in upholding the rules of the interests of justice, so that they don't inflame damages or suppress evidence? The IBA guidelines on conflicts of interest, the latest edition 2024, considers third-party funders to bear the identity of the funded party, and they require disclosure of the funder. So the question is, should they disclose any relationship between the third-party funder and the arbitrator, not just the funded party? Any witnesses, particularly expert witnesses who may be on the continuous payroll of these funders? Quantum experts in particular are very imaginative and can become even more imaginative when they act constantly for the same party. So these are the kinds of problems that I have. Any persons, should they disclose relationships perhaps with the non-funded party's lawyer? So there may be those sorts of situations as well. So there's a number of issues where I think there needs to be regulation to protect. And as I say, I come back to the facts. Fund managers have very limited ethics. Let's be honest about it. Money men have no ethics except making of money. We've seen that with how Goldman Sachs has behaved when they did what's that famous case in England where the Libyan Investment Authority sued Goldman Sachs And there were all those salacious stories of how they got business. And we know about that in 1MDB in Malaysia as well. So there really needs to be a code of ethics that binds what the funders do. Because if there isn't, that's the problem with financialization of justice. So thank you.
Many thanks, Dr. Valentin. And now it's your turn, Victoria, to provide your views on ethical rules and how we can regulate them.
Thank you very much. That actually was an excellent segue I wanted to highlight an article that I've written on this exact topic. It's called Keep to the Code, a Global Code of Conduct for Third-Party Funders. I published it in the Boston University Law Review in December of 2022, and it's free on the internet. You can just search for it and read it. So I'll just give you a quick preview of what's in the article. Basically, I propose that funders are engaging in what I call regulatory arbitrage, or they can engage in regulatory arbitrage. And what I mean by that is arbitrage opportunity is when you exploit gaps, right? So arbitrage is a term that typically comes up in financial services, but I'm using it here to respond to funders and saying that they can be exploiting gaps in the regulatory systems across the world between and among the various nations. And so I actually think we should have a global code of conduct, and that's what I propose in the article. And just to give you a preview of some of the areas, I think that the code of conduct regulation should be grouped into categories based on which relationships you're interested in regulating. So in the article, I propose various provisions with respect to ethics that can be global and universal to regulate each type of relationship. So there's the funder-funded party relationship, where we're looking for trying to ensure there isn't excessive any control, making sure that advertising is not false or misleading, making sure there's clear information given to the party about funding, et cetera. Then we have the funder-attorney relationship, because there's always an attorney in the case or a law firm in the case. And the idea here being that the funder is not engaging in interfering in the attorney-client relationship or otherwise controlling the attorney in ways that interfere with the client's own interests. So that's important as well. Then we have the funder legal system relationship, because the funders are engaging in funding dispute settlement. And so you have a potential for conflicts of interest involving judges or arbitrators, and you have potential for disruption to the legal system if a funder unexpectedly withdraws or terminates their funding in the middle of a case and the party has no money to continue or is in a difficult position. And so these are some of the things that come up with the funder legal system relationship. You also have the funder financial system relationship. So these are financial entities. Many of them are regulated in various jurisdictions as financial services providers and therefore have to be licensed. But even in jurisdictions in which they do not have to be licensed, it is important that the funder ensures that it has adequate capitalization, that it has enough money to uphold all the investments that it is making, that it maintains appropriate licenses or registrations that are required, and that it makes accurate, appropriate, clear disclosures, such as in a prospectus, to any investors or potential investors, as well as to any regulatory agencies that regulate financial services, also while maintaining confidentiality and privileges for client information. And then finally, we have the funder-public relationship. Funders don't have a great image with a lot of public figures and also in the public mind. And so funders really have a duty to educate the public, including the legal profession, but as well as the regular person out there who's just hearing about or learning about funding. I also believe that funders and funding entities should take cases on a pro bono basis because there's a lot of really important litigation and arbitration that's happening in the world that is not getting funded because it's not profitable. It's not profitable to seek certain types of justice. And yet I think funders have a duty, because they're profiting from the system, to actually finance some cases on a pro bono basis. So these are just a flavor of some of the things in the article. I highly recommend you just look it up on the internet. You can download it for free and take a look at it. Thank you.
Many thanks, Victoria. Very clear. So we move to our third question. This is, well, different jurisdictions have different approaches to enforcing regulation on third-party funding. Some rely on voluntary self-regulation, Others have code of ethics, which may be enforceable to varying degrees, and others have compulsory regulations. In particular, for example, the European Union has proposals submitted by the Parliament, which may be passed as directive. So, which approach do you think is preferred according to your experiences and to your analysis? And I would like to give the floor now again to Kim, please. Thank you.
Thank you very much. And this was another topic which our Law Reform Commission subcommittee consulted the public on, made recommendations on, and where there was implementation in the end. And certainly there was considerable expression of different views as to whether there should be some kind of regulator, whether one existing in Hong Kong already in the financial services sector, or a new one that would regulate compliance, or whether it should be largely left to tribunals and courts. And in the end, the conclusion was that the approach to regulation should be what we in Hong Kong, and I know lots of other jurisdictions, called light touch. And that's why we opted for this code of practice for third-party funders. And may I mention that in the legal culture of Hong Kong, these kind of codes or guidelines are widely used, including by our Hong Kong Monetary Authority, Securities and Futures Commissions, and others. So in terms of coming to third-party funding, what was decided to do was to issue this code of practice I've already mentioned, and then provide in the legislation that non-compliance with first the code of practice, and in another provision with disclosure obligations, which are mandated by law, would not of themselves render, and the expression used is render any person liable to any judicial or other proceedings. In other words, the breach of itself did not give rise to a civil action or a criminal action. However, the failure to comply with the provision of the code of practice was a matter, or with the disclosure obligations, may be taken into account by any court or any arbitral tribunal if it's relevant to a question being decided by the court or arbitral tribunal. So in the end, it was decided, as I've said, that the tribunal or a court would be the entity that would decide what the consequences of breach were. And if I may I just go back to a couple of points our colleagues, Dato' Nitin and Victoria, made. First of all, in Hong Kong, with this review, our obligation, our duty was primarily to look at the relationship between the funder and the funded party in the public interest. In terms of capital raising, other matters that Victoria's mentioned, for us in Hong Kong, it was considered we're a highly regulated financial services centre, and that there was a framework for regulating those areas. But to the point that's been made about the critical importance of having conflicts procedures, of making sure that disclosures are made, and that there are ethical boundaries, that there's non-interference with the duties of the lawyers, the code of practice which we have, although it does address some other aspects specific to the funded party funder relationship, certainly focuses on the obligations of the funder to maintain a conflicts procedure, to update it, and to ensure that disclosure is made, amongst other things. So, but to get back to the point, sorry, is Alvaro still there?
No, he seems to have fallen
Maybe
off.
I will stop talking. Be away from Alvaro.
I was just noticing that. I think we'll just continue to proceed. Hopefully he'll be able to rejoin us.
Okay.
So
maybe I finished from my
sure, go ahead.
So that's just to recap then. In Hong Kong, the ultimate supervision and regulation of breach is by the tribunal and or the courts.
Great, thanks, Kim. So I'll just touch on the question of enforcement. Alvaro has returned. Welcome back, Alvaro. I'll just introduce the question of enforcement, which is in the same article that I mentioned earlier, which is called Keep to the Code, a Global Code of Conduct of Third-Party Funding. And so I actually talk about enforcement, and there's a lot of possibilities for enforcement. One of the challenges is that in order for any sort of code of conduct or ethics or code of practice to be effective, your code has to have enforcement mechanisms that actually have teeth. So not just some generalized, we will endeavor to comply or something like that, or a mechanism that may almost never get used. For example, in some self-regulatory regimes, there's the sole method of disciplining a funder for non-compliance is expulsion from the organization, which is such an extreme penalty that no one uses it. And there's a question of whether or not it's really effective. So I talk in the article about a few possibilities of what might be more effective. One of the things that I think is really fascinating is we have the New York Convention in International Arbitration. That's a really effective example of a document that lists international norms that have global application, but local enforcement. So we have this document that says broadly, these are our principles regarding how we're going to treat international arbitration, but each local jurisdiction is left to determine, well, what are the local rules regarding how you file for an application to compel arbitration or to confirm an award or annul an award? What are the procedures to do that? All that is locally done. So I actually think it's an excellent model, and it's actually worked really well and has been adopted widely across the world. And so something like that might potentially work for a global code of conduct for funders, with each individual jurisdiction that would sign on to the code having an opportunity to tailor the enforcement locally to their needs. Some examples that already exist in terms of funder enforcement include court oversight. This is one of the oldest means. In many jurisdictions, the first way the regulators get to learn about funding is through a court case. And so the judges are the first line regulators. Funder self-governance, I mentioned earlier, there are quite a few funder self-governance organizations around the world. The biggest issue with those organizations is the enforcement mechanism. If there aren't any teeth, you're not going to get real enforcement. One sort of indirect regulation mechanism is attorney regulation. So if we put ethical rules and regulations on attorneys, and we say, to attorneys that, if you're going to be in danger of violating one of your ethical rules, you have to withdraw from the case, that indirectly is a way for the attorney to say to the funder, well, you need to stop trying to control what's happening in the case or whatever it may be, or else I will withdraw. And that's kind of indirect regulation of funding. Financial services industry regulation, which we just already talked about, and Kim mentioned the experience in Hong Kong. And then we also have statutory regimes that already exist that may already apply to funding. So some jurisdictions say that funding's a type of insurance, and insurance is a heavily regulated industry, so there might be some options there too. And then we also have non-governmental and multinational approaches. So just one example, UNCITRAL is currently engaged in Working Group 3 on investor state arbitration reform. They are looking at third-party funding regulations, and they are also looking at providing provisions that states can use to implement in their treaties. And also ICSID has a rule on third-party funding now. So those are just a few examples. The final one I just want to quickly highlight is that most jurisdictions in the world, or many jurisdictions in the world, still have no regulation of funding. That does not include prohibition. Some jurisdictions, of course, like Malaysia, have prohibitions, but there's some jurisdictions that just say nothing. And that's also a wait and see approach to regulation. So those are a few examples of enforcement possibilities. Thanks so much.
Well, thanks, Victoria. So, Nitin, it is your
Okay. As the obvious skeptic here on the panel, I would like criminal legislation regulating or punishing acts of misconduct by funders. You think about the situation. If somebody interferes with the administration of justice in court by suborning a witness, by suppressing evidence, by inflating damages, the court has the power, at least under our jurisdictional rules, to sentence them to prison or a hefty fine for contempt of court for interfering with the administration of justice. I don't think there is a similar provision if somebody interferes with arbitrations. If you and arbitrations are across border. The enforceability of arbitrations under the New York Convention is what, 177 countries now with an award. So there's enormous scope for abuse. And again, I come back to the Sulu claimants case as a Malaysian that stinks in my mind, that there is a case where, you know, clearly something went very wrong, and they were able to take that because they had deep pockets. They could go and try and register something that was clearly wrong in numerous jurisdictions and incur huge costs with no consequences for the third-party funder. I mean, if you look at Therium's website, who were the funders, they boast about having funded claims with total value of circa 100 billion, of which probably a significant portion was the Sulu claimants case. There's no downside for them other than spent costs. You know, they can be speculative, they can do whatever they want. So criminal legislation would be ideal. But even if you don't have that, and I come back to the point that Victoria made about the New York Convention. I mean, that's what, 70, 80 years old. It would be nice to update it, if it were possible, to include a right to refuse registration if there was a breach of ethics, which could be in different jurisdictions, if there was a non-compliance with ethics on third-party funding. And it could be left to each jurisdiction, what is the regulation for third-party funding? But that would be an incentive for third-party funders to comply with any ethical considerations that may appear in different jurisdictions. So that's one possible thing you could have. Because I think criminal law is going to be difficult. But that would be one possible way I think you could do it. Institutional arbitrational rules, which strictly regulate, is another way to do it, and probably a faster way to regulate third-party funding. Ideal would be, of course, a global set of rules, you know, and I'm glad to hear that UNCITRAL is looking into it, because that's probably the best way to get into it. The other way would be, of course, if the IBA updates and has a specific set of soft law rules, if you like, on third-party funding. So these are some of the thoughts that I have about how we should regulate third-party funding and enforce. There should be some bite. There should be some teeth to bite third-party funders who misbehave in the conduct of the arbitration. Again, I'm not so much focused on third-party funder with funded party, but third-party funder in the conduct of the arbitration vis-a-vis the unfunded party. That, to me, is where we should be looking.
Many thanks, Dr. Monitin. I fully agree with your views regarding the Sulu matter, and we take note also of your proposal to update the New York Convention, which is difficult, but I think affordable. So we move to our fourth question for our panelists. This is, what role do arbitral institutions, tribunals, and practitioners play in regulating or ensuring the proper use of third-party funding? And I think this is probably one of the key issues of what we have ahead. So I would like to give the floor first to Victoria to answer this question.
Thank you, Alvaro. I'm going to take the question of the perspective of institutions. I previously was deputy director of the North America office of the ICC. And actually, that's where I first noticed third-party funding. We were seeing these entities paying fees in cases. And I said, what is this? And that's how I even discovered third-party funding to begin researching it. But one of the things that I think institutions are particularly interested in is disclosure to check for and avoid arbitrator conflicts of interest, or to waive, for parties to waive conflicts of interest. That is crucial. The reason why that's crucial for arbitral institutions is because they are very focused on enforceable awards. The institution's reputation depends upon the awards issued by the arbitrators that use that institution's rules being enforceable in whatever jurisdiction those awards will be taken to. And so this is one of the main reasons why the disclosure rule is one of the main things that you'll see if you look across the various funding rules, or arbitral rules that have come out that talk about funding. They're all talking about disclosure, different types of disclosure, different amounts of disclosure, but they're all talking about disclosure. The third reason I would say would be avoiding court interference in arbitration. Given that there are more and more jurisdictions that are arbitration friendly jurisdictions that are having laws on third-party funding on the books, there may be a tendency for parties who are the non-funded party in the case to want to go to the court system and say, hey, there's a funded party in my arbitration. Can you stop that, or can you interfere? And arbitral institutions want to avoid, if they can, court interference in the arbitral proceedings. And so it's in their best interest to try to regulate this or provide inherent powers to the arbitrator to regulate this, to try to sort of stave that off. And then the last one I'll mention is legitimacy. Funding and arbitral institutions are very concerned about legitimacy, especially right now, because there's concern about states potentially withdrawing from the system. International arbitration enjoys wide support because of the New York Convention, but also the ISDS Convention, the Washington Convention on Investor-State Dispute Settlement. And there have been dangers in recent years of states sort of threatening to withdraw or actually withdrawing. And the question right now is, before UNCITRAL, as they are looking at ISDS, there are a lot of states that are questioning the legitimacy of the system because they didn't have a chance to be part of the negotiating table at the time the system was created. Funding just adds fuel to that fire that's already existing of states calling for reform and thinking the system is unfair. And that is something that institutions fear, because if the states start pulling out, then their courts might become hostile to arbitration, which, if you go back many, many decades, there was a lot of hostility to arbitration. And we're hoping that we're not going to go back to that place. So these are some of the perspectives of institutions and why they really feel it's important to regulate funding, to pay attention to funding, to be the front line in making sure that the system stays robust and that the system can be trusted by states and entities. Thanks.
Okay, thanks, Victoria. Very interesting perspective from institutions. So I would like to give the floor to Kim to provide us with the perspectives from arbitral tribunals.
Thank you very much. But if I may, Alvaro, may I just go back to a point Dato' Nitin mentioned about the possibility of criminal sanctions in third-party funding. May I mention that in Hong Kong, there is a provision in Part 10A dealing with third-party funding, which expressly says that other illegality is not affected, and that this non-application of the doctrines of championing and maintenance to third-party funding as provided for in this ordinance does not affect any rule of law as to the cases in which a contract's to be treated as contrary to public policy or otherwise illegal. Now, I know that's a general statement, not going to the kind of abusive process that you were referring to, but in Hong Kong, if anybody is behaving contrary to the many, we have a criminal law framework like most jurisdictions, those laws will still apply. But now, coming back to the role of prospective tribunals. As we know, the tribunal has key functions to ensure fairness and due process. And third-party funding is a form of funding that's come in, and in at least 2 jurisdictions in Asia, Singapore and Hong Kong, there's a clear framework of, as we've been talking about, ethical obligations and financial obligations, and including disclosure obligations. And these disclosure obligations, as we've been talking about, are critically important to assist containment or elimination of conflicts, and also are very relevant to costs. And may I just come to the conflicts exercise tribunals perform, which of course impacts on them sometimes, but also can arise with parties, is an important power they have in this context of third-party funding, but also costs. And why do I mention costs? Because in many jurisdictions, including Hong Kong, but others too, the tribunal has the power to award reasonable costs. And in the context of third-party funding, there has been a discussion as to whether reasonable costs include the premium that a funded party pays to the funder. And certainly from the perspective of certain funders and parties, they consider that that premium should be included in the costs awarded to a successful funded party. But in Hong Kong anyway, there's been quite a discussion about whether that could possibly come within the scope of the definition of reasonable costs, But that's why disclosure early on is so important. So a party who's not funded knows what they're potentially, the kind of arguments they're potentially facing. But then coming back to the more general powers, as I mentioned one of the earlier topics we discussed, the tribunal has a power under the arbitration ordinance in the third-party funding section to, and I quote again, take into account any failure or compliance in a funding agreement that's relevant to an issue before it. So to that extent, there may be circumstances where a tribunal can make orders that are in response to assertions of, for example, non-compliance by a funder, for example, in an arbitration that bears on the arbitration, whether it's a disclosure or failure to comply with the code of conduct.
Okay, thank you very much, Kim. So, Nitin, could you please provide your views from the practitioner's perspective?
Okay, from a practitioner's perspective, what could practitioners do? I think there's three major roles that practitioners can play. One, of course, is through influencing the making of hard law legislation in their own jurisdictions at the point of entry of third-party funders into a jurisdiction. Once the third-party funders come in and they're able to lobby, I'm afraid lawyers have somewhat less influence than the deep pockets of funders. But at the point of entry, there is certainly a role. Secondly, through drafting and providing guidance on rules to be enforced by institutions, the arbitral institutions, strengthening the regulations in the various, well, in Malaysia, it'd be the AIAC rules, in Singapore, it'd be the SIAC rules, and so on and so forth. And thirdly, I think, and this is probably goes back to this global code, through influencing the making of soft law applicable internationally. And again, I think the strongest role is through the IBA, either through strengthening the guidelines in the 2024 conflict guidelines on conflicts of interest, or having a separate guideline entirely on third-party funding. And while these soft law is not, it's often, as I think all the panelists are aware, is taken into consideration, and great weight is given to this kind of soft law by courts around the world. The other thing, of course, that lawyers can do is increase self-regulation. I think Kim suggested that you increase the code of ethics, that you make provision in the code of ethics in your own jurisdiction. The problem I have with that, it's in principle, I think that's a great idea, but the problem is you're then putting more and more weight on the lawyer to ensure that everything is done, rather than on the pockets, the deep pockets. And there is an enormous temptation on, I mean, we know it. There are lawyers who can give way in gray cases or allow themselves to be swayed in certain instances by their paymasters. So while there is a need to tighten the code of ethics to require lawyers to properly clear conflicts, to withdraw from cases if they suspect something odd is going on, to disclose various things to the tribunal, it's not unheard of in any jurisdictions for lawyers to become conveniently blind when they see things happening that affect their pockets. And yes, there can be a sanction after the event on the lawyer, but that doesn't help the unfunded party who got an award against him because of misbehavior. And again, I come back to the fact that in courts, if something happens, you can go back to the court to set it aside if there's been misconduct, if there's been a fraud in the court. But an arbitral tribunal, once it has delivered its award, is functus officio. After that, even if there's a discovery of some misconduct, your remedies lie through the New York Convention rules. But you can't go back to the arbitral tribunals to remedy the wrong, to investigate whether there has been a misbehavior of any kind. So that is, so that's really the concerns I have. And that's why I'm such a fan. And that's why, coming back to my point, listening to me, you might think I'm against legalizing third-party funding. But in actual fact, I am so much in favor of legalizing and regulating properly third-party funding, because the alternative is to have an unregulated industry. Coming back to the Sulu claimants case, if we had the proper legislation in Malaysia to control and regulate third-party funding, including perhaps criminal law if applicable, we might have had more teeth to fight that kind of misbehavior. It is the complete absence of legislation in this jurisdiction that allows this kind of thing to happen. Thank you.
Many thanks, Nitin. We take note of the need to regulate, with which I really agree. And we move now to our last question. Well, as you know, one of the common arguments in favor of third-party funding is that it increases access to justice. But in some cases, like the Zulu case that you mentioned, that Nitin, third-party funding may in fact distort justice, particularly with respect to unfunded parties. So how can we balance these tensions and protect access to justice for both parties, for the funded and for the unfunded party? And I would like to give the floor first to Victoria, who I think has written a very interesting article about the impact of third-party funding on access to civil justice. Thank you.
Thank you so much, Alvaro, and I'm happy to explain a little bit about that article to the audience. I just wanted to highlight something that Nitin just raised, which is crucially important. The New York Convention took 80 years, as Nitin mentioned earlier, to get to 170 plus state parties. So although in my prior article, I say that might be a good model, we can't move that slowly. The third-party funding industry moves so quickly, we can't move that slow. So I actually like Nitin's suggestion of the IBA, potentially starting with soft law, something that is voluntary, at least, to begin the conversation as we might move towards something with more teeth, because I think something with more teeth is going to take more time, and this industry is so rapidly evolving that we should move quickly. So that's just one aside I wanted to add in. So thank you, Alvaro, for mentioning my other article. So I have an article that is titled Rethinking the Impact of Third-Party Funding on Access to Civil Justice. And it's published in the DePaul Law Review, DEPAUL. Again, also available on the internet. You can just search my name, you'll be able to find it. And basically in this article, I engage in a thought experiment about who are the parties that are receiving funding and who are the parties that are not able to access justice, not able to receive funding. And I go through an entire sort of thought experiment, and I come up with essentially two broad categories of parties that don't really have access to funding. One is what I call unfunded losers. So, and I don't mean losers in a pejorative sense, but in the sense people or parties likely to lose the case are generally not funded. Makes sense, right? Funders want to make money. They don't want to fund losers typically. There may be some outlier scenarios out there, but for the most part, they're trying to fund winners. And so in situations in which a respondent is potentially likely to lose a case, that respondent would not receive funding or would be less likely to receive funding. Similarly, a claimant. And so this is something that is really challenging in terms of trying to determine how we can get access to justice through funding for unfunded parties that are likely to lose. The other type is unfunded winners or unfunded parties that are likely to win the case. And here I split this into two categories. One is in civil disputes, unfunded winners often can't get funding if they have non-damages claims. So if funders are trying to make money, the funder is looking at, well, what's the size of the money damages and what's going to be my take and how much is the case going to cost? And they put all this into their formula and they spit out, okay, here's the value of the claim and decide whether to fund. But if someone, a party is seeking a declaratory judgment or a specific performance of a contract or any one of these things or declaration of the validity of a patent, those claims in and of themselves don't necessarily carry any dollar value with them. There can be dollar value claims attached to them, but the claims themselves are essentially non-monetary claims. And so those cases may not be funded, even though they may be winners, because there's no money that's going to come out of that case. Well, those claimants may not be able to get access to justice. For example, if you're a small startup company and you have a valuable patent, and some other larger entity is infringing on your patent, you may not have the funds available to go against that larger entity and get your patent adjudged valid, or bring your claim for patent infringement, which is a very expensive claim to bring. And the funder is going to say, well, what's the value here? What can I, get a gain off of if I fund you? And so this is another big issue. And then the second type of unfunded winner is potentially respondents. So to the extent that there's an argument made, there are frivolous claims in the system, the argument that funders don't fund claims that lose also leads to them not funding claims or claims that win when that quote unquote claim is brought by a respondent. So in my article, I argue that a respondent's claim is a claim for no liability. So winning for a respondent is no liability, right? Well, that has value to the respondent because they don't have to pay anything to the claimant, but there's not a pot of money that or damages that the respondent receives by winning their no liability claim, meaning you win, you don't have to pay the claimant. Congratulations, there's no pot of money for the funder. So the funders will say, we're not interested. This is why there isn't a market at this time for respondent fundings, a major market. There are a few funders that do fund respondents, but it's not enough of a market to call it a market, right? This is a huge problem because every single case has a respondent, right? If without a respondent, there's no arbitration, and yet respondents don't have an access to a market for funding in any real sense. There are a few examples of insurance or specialty arrangements, equity funding. There's a few complicated things that exist out there, but for the most part, respondents are really the key here for access to justice. And then to take it one step further, investor state dispute settlement. I keep mentioning it because this is what the states are arguing. They're saying we're the respondents in all these ISDS claims, which means when these claimants win, we, the states, are the ones that have to pay. And that money comes from our public treasury, our tax dollars, and it's going in the pocket of a funder. And we don't like it. That's what the states are saying. And there's no way for those states to get access to that same market for funding. So they're unhappy about that. So that's something that's coming up too. I think they're going to regulate it. I don't think they're going to prohibit it, but it's interesting to see. So those are some examples from the article. Thank you.
Many thanks, Victoria. So Nitin, we have very short time, but I would like to have your views on this.
Okay, thank you. Really, I think everything I think about this is on this question of the unfunded litigant has best been put by Gavin Griffiths in the case I cited earlier, RSM Productions against Santa Lucia and his assenting judgment on costs. I know he's dialed back on it thereafter because he came under a lot of criticism, but I think he was right. And if I can just quote some of the things he said, it is increasingly common, in that case it was a BIT claim, to be funded by a third-party funder who shares in the risks, the rewards of success, but if security for costs orders are not made, to risk no more than its spent costs in the event of failure. Such a business plan for a related or professional funder is to embrace the gambler's nirvana. Heads I win, and tails I do not lose. It is no reach to find that as strangers to the BIT entitlement, such funders should also remain at the same real risk level for costs as the nominal claimant. So it seems to me that one way to rebalance it and perhaps prevent more of these any kinds of frivolous claims is to create a presumption that if there is a third-party funder, security for costs of the unfunded party should be awarded. There are two situations where you might have third-party funding. One is the situation where you have a large corporation which basically wants to outsource all of its litigation risks and management to a third-party funder, but is not an insolvent company, and so you can recover your costs in the end of the day. But there is the second situation, the situation of the so-called access to justice for an indigent litigant. And there you have a situation where the litigant gets funded to claim, and if he loses, the winning party, the unfunded party, is not able to recover his costs because it is an impecunious claimant. So to me, it seems that you redress the balance. One immediate practical way is to immediately order security for costs unless the litigant, which is funded, can show that it would have the finances to pay any order for costs made eventually. A second way, of course, is to closely monitor the costs claims of funded parties. Perhaps with my limited experience, I've not done many claims where there are funded litigants, but I have done a few outside Malaysia. And I find varied ranks of lawyers on the other side. There's a case I did some years ago in a Middle Eastern country, and there were what, 8, 9, 10 people on the other side, led by a very senior QC, over 40 years in practice. And on our side, there were only 3 people. When the cost claims were submitted, their trainee solicitor per hour rate was higher than my rate, and I'm almost 40 years in practice. And I suspect that was because they were being funded to some extent. They lost, so they didn't get their money, and we succeeded. But having succeeded, we didn't get our costs either, because there was no security for costs order in that case. So these are the kinds of problems that concern me. Thanks.
Thank you very much. That's Ronnie team. And so, Kim, if you can provide your answers to this question, it would be very helpful as well.
Thank you very much. I mean, access for justice is one of the rationales for third-party funding. Third-party funding, as we know, is one form of arbitration funding in other jurisdictions, including Hong Kong, for example. The other forms include contingency fees, outcome-related fee structures, conditional fees, and also insurance. So it's, may I mention, as I know we're running out of time, in Hong Kong, since third-party funding was introduced in 2019 February, it's estimated only 5.5% of these are commercial cases have actually disclosed their third-party funding. So the floodgates in Hong Kong have not been opened. There's been about 89 cases as of April 30 this year, thanks to the Department of Justice for providing that statistic. But that being said, okay, the tools or the mechanisms that in Hong Kong we thought were key parts, it's repetitive again, to resisting, containing abuses, avoiding abuses, hopefully, were ensure disclosure that sunlight, the transparency, so then that goes to minimizing conflicts, assisting tribunals to supervise fairly and efficiently, taking into account recosts to ensure they're reasonable. As has already been said, ensuring that arbitration institutions do have provisions that address third-party funding. And as you've all been talking about, having soft law is also very precious. Now, going to 2 points that Nitin was talking about in terms of security for costs and power of tribunals to make cost orders against third-party funders, we in Hong Kong invited comments, having made recommendations on both those topics. With security for costs applications, we thought, I know it's a Hong Kong context, the law was adequate in terms of the criteria and circumstances in which security for costs could be ordered. There's a mechanism under our ordinance. In terms of the power to award costs against third parties, interestingly, the majority of people who made submissions to us thought that was a good idea. And in principle, the Law Reform Commission thought it was a good idea, but what was the obstacle? Why did we recommend that it should be reviewed? It's because, as we all know, under the New York Convention, under our UNCITRAL model law, arbitration agreements need to be in writing, and the parties who have the right to participate in arbitrations are the parties to that arbitration agreement. Sure, there's legislation, third-party rights, but that's not, well, question, has anyone ever explored that in this context? But they're third-party rights. So going back, I think one of the areas that I hope Hong Kong, and some may not like this, but certainly the majority view was having the power of tribunal in appropriate circumstances to award costs against third parties, including funders, just like courts can, was one mechanism that could assist. Thank you.
Many thanks, Tim. So we have finalized with the Q&A session, and now we move to the questions from the audience. I have 3 questions here, and I ask for the assistance of the organizers because as I disconnected for 1 minute, I don't have the first questions. So I will ask the questions I have here, and then if the organizers may help me with the rest of the questions, I would be very grateful. Well, the first question is from Juen Lee, and I guess this is for Kim. It is very straightforward. How many TPA cases in Hong Kong? And I don't know if you have that data, Kim.
Thank you very much. In fact, I do have the statistics. Now, is that how many cases of disclosure of third-party funding in Hong Kong, or how many cases about issues arising under the legislation?
Well,
yeah.
Probably both. It could be more interesting to have both.
Okay.
Figures.
In terms of the statistics, as I said, the Department of Justice gave me the statistics, the Hong Kong Department of Justice gave me the statistics up to April 30. And the reason I'm doing is looking at my numbers to make sure they're correct. In the period from 2 February 2019 to 30 April 2024, there has been disclosure of 89 of third-party funding in 89 cases. And on the back of the envelope calculation by reference to publicly available data as to the number of cases that have been filed since roughly February 2019 to April 2024, that's 5.5, around order of magnitude, 5.5% of cases, arbitration cases seated in Hong Kong. So as I mentioned probably too quickly, certainly there's third-party funding. It had a fairly slow start. It then took off, then slowed down a bit, but it hasn't been a huge proportion of cases. As to whether there's any case law on Part 10A of the Arbitration Ordinance, which is the regime for third-party funding, I've been looking again recently because I'm an editor for the Civil Law of Procedure in Hong Kong, and so far haven't been able to find a case on third-party funding of arbitration. There are a number of cases in Hong Kong on champity and maintenance in the context of insolvency, family law, access to justice, but so far can't find cases where there's been an issue arising under Part 10A of the Arbitration Ordinance, third-party funding, which suggests that so far it's worked okay, nor do I understand there's been disclosure of disputes between funded party and funder, because as I mentioned probably too quickly, there's an obligation on the funder to provide that information to the advisory body for third-party funding.
Okay, many thanks, Kim. We have another question from Venezuela. Jorge Gonzalez says that this is a very good event. Thank you very much. And the question is the following. In the absence of a mandatory code of conduct for third-party funders, how do you suggest that it can be regulated in international arbitration on a case-by-case basis? And probably this question is for Victoria.
Thank you. Thank you so much for the question, Jorge. So I think that we should always remember that in pretty much every international arbitration set of rules, there is a provision about the powers of the arbitral tribunal, the inherent power of the tribunal to control the conduct of the proceedings. It's very similar to the inherent power of judges to control the conduct of litigation. And there have been several cases that have ruled that the inherent power of the arbitrators extends to power over interference in the arbitral proceeding. And the question would be, how is the funding showing up in the case? So if a party just says, I have a funder, there is funding, that in and of itself may not necessarily be interference to sort of invoke the powers of the arbitrator to inherently regulate that. But if it's the funder sitting in the room, or the funder is trying to replace counsel, or the funder is insisting on sitting into settlement negotiations or trying to approve settlement, it would depend on the behavior of the funder. But there is a level at which the behavior of the funder or the involvement of the funder would rise to the level of a tribunal saying this is something that's affecting the conduct of the proceeding, and therefore I as the arbitral tribunal, or we as the arbitral tribunal, or I as the arbitrator, can then regulate the involvement of the funder. So that's, I think, where the line would be drawn. I mean, the bigger overarching question is disclosure. And under the inherent powers of the arbitrator can ask for disclosure even if there is no disclosure rule, which often happens. And that's one of the reasons why we even know about situations of funding, even when there is no disclosure rule. So those are some examples of how it could be regulated on a case-by-case basis. Thanks.
Many thanks, Victoria. Okay, we have another question from Vishnu Menon. The question is the following. The Sulu case was mentioned as being an example of the filing of meritorious and inflated claims, but wouldn't this be an exception? And this question, I think, is more for that team. Maybe you can expand on this.
Okay, thank you. Yes, but it is an unusual case. But there are the point to note is there are no sanctions on the third-party funder. All that they have suffered is spent costs. They spent a few million in the hope that they might have recovered tens of billions. Oh, I think that was the sort of sum, if I remember correctly, that we were talking about. So, you know, you think about how venture capital works in the world, or angel investing. They scatter their seeds across 50 companies. You only need one hit to recover all that money and more. And you will find, in the absence of regulation, with teeth, you will find, and in the absence of any comeback for these funders, you will find more and more of these kinds of cases being filed. The Sulu case is unusual only because it is a commercial claim against a country. But the point that I think was made by Victoria is that you're seeing these kinds of claims being made in ISDSs, you know, in investor-state disputes, particularly against small, weak countries that may not have the finances. That nobody will take these kinds of unmeritorious claims against the US or the UK or Germany or France because they have a lot of money. But they may take these claims against Venezuela or Ecuador or Santa Lucia or Kitts and Nevis or Malawi or poor countries that can't defend themselves with a great deal of money. So it is the one case, I think, that the exception that will prove the rule that if you don't have teeth, if third-party funders themselves are not regulated, you will have more problems like this occurring. Thank you. I hope that answers the question, Vishnu.
Okay, thank you very much. And I think we have room for our last question. This is from Iliana Nawi from the AGC. As far as Malaysia is concerned, if Malaysia were to legislate TPF, would it be proper to allow TPF in an arbitration involvement government as a party, or should there be a special TPF provision for arbitration involving government as a party? And I guess this is also for that only team.
Oh, I absolutely think the Malaysian government must be subject to the same rules as everybody else. The government, we live in a country governed by the rule of law. You can't have a different rule for the government than you have for everybody else. Aside from anything else, if you create a carve-out for the government, there will be no protection for anybody else, or there will be limited protection because the government of Malaysia, I'm sorry, Puan Iliana, but home truth, the government of Malaysia, like every government around the world, I'll add that rider in, only moves when their own interests are threatened. They do not necessarily move as fast to protect normal citizens and ordinary corporations. So yes, I think whatever regulations must involve the government to exactly the same extent. This same argument was raised that government is a special party, and moving a little outside the sphere, when SIPA was introduced, when adjudication was introduced in Malaysia, and there was a suggestion that the government of Malaysia should be made an exception party, should be excluded, a carve-out should be made. And luckily, common sense prevailed, good sense prevailed, and the government was made a party to that legislation, as a result of which we do get amendments being made and proper protections and proper regulations that apply to everybody being made. Thank you.
Thank you very, very much, Datoni team. So we have reached the end of our session. I would like to thank you again, our excellent speakers, Professor Victoria Samon, Kim Rooney, and Datoni team. I hope it has been interesting and helpful for all the audience, and I encourage you to go on with the next session. Thank you very much, and thank you very much to our organizers as well.
Thank you, Alvaro. Thank you very much, Alvaro, for moderating. Thanks, Kim and Victoria. Bye.
Thank you, Alvaro. Thank you. Bye-bye.
Thank you to our panel of speakers and moderator for the comprehensive session. Ladies and gentlemen, we shall now have a short 10-minute break. And we look forward to seeing you back at 12 p.m. to convene for the second and final session of this webinar. Welcome back, everyone. We will now commence the second session of the day, titled Justice, Professional Responsibility, Ethics, and Integrity. Can regulations and a code of conduct serve them all? This session will also run for 1 hour, followed by 15 minutes of questions and answers at the end. Among other objectives, this session aims to, first, examine the need to regulate the third-party funding industry through the introduction of a standard code of ethics for funders and the viable ways to ensure effective implementation of such regulation. Second, to discuss the potential establishment of a central regulatory body for third-party funders, its jurisdiction, and the power to sanction defiant funders. And third, to explore other possible measures that can be undertaken to maintain ethical conduct among funders and to preserve the sanctity of the justice system. The moderator for our second session is Professor Dr. Jason Chua, Dean and Professor of International Commercial Law at the Faculty of Law, University Malaya. Professor Dr. Jason is a Dean of Law at University Malaya, and prior to his appointment to University Malaya, was Head of School and Professor of Commercial and Maritime Law at City University of London. He graduated with first-class honours from University Malaya and has held 4 awards at St. John's College, University of Cambridge. He has published 13 books and over 200 journal articles. His works have been cited in the UK, US, Europe, and Asia. In Malaysia, he is working with various government bodies, and internationally, he has been a consultant to the UK government, the ICC, UNCITRAL, Association of British Insurers, EU Commission, etc. His article titled Third-Party Arbitration Financing's Unholy Shadow, published in The Edge in June of 2023, has been cited widely. Professor Dr. Jason shall be joined by our esteemed panel comprising Professor Catherine A. Rogers, who is from the Department of Legal Studies, Bocconi University, and the co-chair of the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration. Ms. Marjolein van den Bosch-Buren, Investment Manager, Head of Enforcement, APAC at Omni Bridgeway, and Dr. Jan Eken, Assistant Professor, Durham School of Law, and member of Durham International Dispute Resolution Institute. Let us give them all a virtual round of applause.
Right, I shall take over from Ms. Bhavini Singh. Thank you for that very kind and generous introduction. First of all, a very warm welcome to the second session, and thank you to the Legal Affairs Division of the Prime Minister's Department for putting this together, and of course, thank you also to the AIAC for hosting this event. Ms. Singh has already alluded to the objectives for this second session, and I'm sure for those of you who have been with us over the first session chaired very admirably by Mr. Lopez de Gamu, you will have been treated to a very, very distinguished and intellectual discussion about some of the challenges around regulation and around the concerns that various stakeholders have over third-party arbitration funding. Now, for this session, I like our presenters largely to focus on what we discussed a couple of days back as their hobby horses. And so these are issues that perhaps vex them a little, and we would like to very much to hear from them. The order of proceedings will be like this, and I hope that you would abide by our rather informal protocol. We'll kick off with a presentation from Dr. John Aiken that will be followed by a presentation by Marjolein, and then we will have a wrap-up of the presentations by Catherine. So that's the order of the presentations. So this is going to be a little bit different from the last session. We'll have structured presentations, and then we will pick up on the themes that they have raised. And of course, we will then explore those themes in greater detail, and finally opening up to the floor for further questions and comments at the end. So each panel speaker has been given roughly 10 to 12 minutes. We want to keep this really brief just so that we can have a longer time to explore some of the very, very critical and important issues at hand. So without me going on and on again, I would invite John to give us his presentation. John, you have about 10, 12 minutes. Thank you.
Jason, thank you very much for this very kind introduction and invitation as well. As we agreed, I will first share my slides actually. I think now you can see that. Okay, perfect. Then hi everyone. We agreed between us that I will give a brief introduction of third-party funding and overview, and my co-panelists will go into further issues, and then we can have discussions as Jason described. So today, what I want to do is that without boring anyone too much, within 10 minutes, giving a brief overview and some issues, what are the relation with access to justice and professional responsibility as our panel title. So third-party funding, as you all know, are basically operating in international commercial arbitration, investment arbitration, and litigation in several jurisdictions around the world. So today's structure, I will give you a little bit the concept background, the case law, and some policy implications, what we might see in the future, and some takeaways, and then I will conclude my presentation. So what third-party funding is? Third-party funding is where a funder provides funds to a party in arbitration in exchange for an agreed return. This is the basic definition. It seems very simple, and then without no issue in this definition. But of course, there are many issues surface as we are discussing. So common law doctrines and everything were already discussed in the previous panel, so I will not go further. So let's give a little bit background why third-party funding is so popular and growing so fast. First of all, one obvious answer is that arbitration is very expensive, and it can be time-consuming for parties, and parties want to transfer the risk of arbitration or litigation to third-party funders to bear this risk. And third-party funders are basically taking this risk to make profit from these proceedings. So companies either do not have money to fund the arbitration proceedings, that's why they are seeking third-party funding, or as I said, companies wish to transfer the risk incurred in the arbitration proceedings to funders. So this is the basic reasons of third-party funding. Major funders around the world, as far as I know, there are over 800 funders in the world operating. When I last checked numbers, I'm sure maybe now even more than that. And there are some major funders are open to public, even in the stock exchange market. And one of the major funder panelists with us today as well. So if we talk about the basic funding agreement and how this mechanism works, basically you need a funding agreement to start this third-party funding process. And this funding agreement is between the funded party and the funder. However, there are of course lawyers are involved, and lawyers can are advising both parties of this agreement, and basically you enter into this agreement. Again, it looks very simple and straightforward, but there are many considerations before this funding agreement can be entered into between the parties. So there are several considerations. These are the amount of damages, the length of the proceedings, the expected value of the client's claim, and whether the claim settles, proceeds to trial, or is appealed. So depending on the platform, depending on the mechanism is entered into, funders are considering these and other relevant factors before they agree to fund a case or not to fund a case. So there are a lot of issues that might potentially be raised with this funding process. And I am actually, my book from Springer is coming out, hopefully. So you will read about this, but very briefly, some issues in investment arbitration raised before the tribunals, and these basically are addressed by different tribunals in different ways, and sometimes in a unanimous way, harmonized way. Sometimes different opinions are raised. So some of these issues I picked here are these discontinuation of arbitration, security for cost, disclosure and conflict of interest, and allocation of cost. Of course, there are other issues, and we don't have time to go into each in detail, but I will give a little bit brief overview of some investment arbitration cases. RSM Production versus St. Lucia case, and Dirk Herzig versus Turkmenistan case. These cases where the third-party funders were present and security for cost orders were granted. Very briefly, the tribunal ordered security for cost, and third-party funding was one of the factors, but in both tribunals, it was not the only factor to order the security for cost, and it was just one of the considerations. That was the main direction. I think that is the general acceptance universally, we can say as well. And then another important issue, allocation of costs, whether one third-party funder involves the process, how this should affect the allocation of costs at the end of the proceedings. So if the winning party basically should be awarded the funder's success fee, as we can address, or not. In investment arbitration, tribunals generally ordered that they do not know why they should take third-party funding arrangements into considerations when ordering allocation of costs. So they basically ordered as if there was no third-party funder. Winning party basically takes all these important costs they spent for legal costs, expert costs, and etc. But they didn't award funders success fees or any relevant cost. However, in commercial arbitration, in different jurisdictions, we saw sometimes different trends. In England and Wales, where I am currently teaching, is basically there are two important case law, and they both granted the funder's success fee to the winning party as well. So in this way, the arbitration tribunals basically ordered the funder's success fee costs to the winning party as well. So the winning party didn't have to pay anything out of his own pocket to the funder. Everything was borne by the losing party at the end. And when the losing party basically challenged this decision, and the English courts also approved this process, because in English Arbitration Act, there's a section called other cost, and basically they say this is the arbitration tribunal's discretion to award success fee within this other cost definition. So in commercial arbitration and investment arbitration, we saw some different trends here. So again, this was the very brief introduction of some of the issues. Now, if we look at the policy implications around the world and the direction we are moving towards, we see more rules regarding third-party funding. So we have IBA guidelines on conflict of interest, SIAC investment arbitration rules, HKIC rules, Article 44, CETA Hong Kong TPF guidelines, of course, ICSID rules, NIV ICSID rules, and these are not exhaustive. There are many ongoing trends and developments in the world specific to third-party funding. So what this means that we are basically seeing more regulations towards third-party funding, and then probably it will highly increase regulations. So I want to conclude before taking too much time so we can continue with the other panelists and Q&A session where we can explore even more. But the EFIV conclusion and my own thoughts here is that probably we will see more regulations. This is a trend we are going through, but we need to be careful because if we regulate some industries heavily, it might be affected negatively, and whether this is the intended result or not is something we need to consider. And but of course, if we completely leave it unregulated, that can create even more problems as well. However, there needs to be an important balance struck between these two, and that's why all the jurisdictions around the world, when they are regulating, they need to be very careful. And in Hong Kong and Singapore, for example, we see trends. There were recent regulations in both jurisdictions, and I wrote one article on this as well, but in the Q&A maybe we can explore more. But in both jurisdictions, it was the light touch approach. So they didn't regulate heavily, and they basically prepared some guidelines. In Singapore, it was more mandatory than Hong Kong. But they were both important legislations we saw. And in England and Wales, it is a self-regulated market, and in general around the world, but the case law sometimes directs you in certain ways, and you need to follow these as well. So that's why there will be some regulations probably around the world, more we will see. And then another important thing, since that is in the title, access to justice. So this is one of the main arguments for third-party funding, why it should be allowed and it should operate freely, because it provides access to justice, and it is undeniable. Because otherwise, some parties or many parties, if not all, could not bring these cases before the tribunals. So these are important considerations that we can think of, but we can elaborate more later in this panel discussion. And important, a few other conclusion that we need to basically think of our ideas very carefully before we make final conclusions. So I will, I think, stop there, and I will leave now the floor to other panelists to continue, and thank you very much again.
Yep. Thanks, John. Thanks very much for that. Marjolein, over to you.
Thank you very much. Well, before I begin, I would like to express my gratitude to the organization and as well as to my co-panelists for having me here today and to discuss this very interesting topic. Before I begin, and we'll share my slides, very briefly, I'm Marjolein van den Bos, and I work with litigation fund Omnibuur for almost 7 years now. But I am a litigation lawyer by training, and I also worked several years as in-house counsel with a Philippine conglomerate in Manila before I joined Omnibuur. So my experience and my views are not just based from the perspective, I think, as a funder, but also, I would say, as a lawyer and in-house counsel. And now let me see if I am also technical enough to share my screen. So there we go. May I just check if you can see this? All right.
Yes, Marjolein.
Okay, very good.
Yeah.
Thank you very much. So there we go. First of all, very briefly, I would like to discuss the background of third-party funding, and then actually who use the funding and why, which kind of parties do it, and why do they go to a funder. I also, because it's often discussed that funding may enhance frivolous claims and how that goes about. I would like to also explain a little bit about the investment criteria and how it works before we actually go ahead and fund the matter. Then, as I was also promised, I could speak a little bit on my hobby horse. I would like to explain the enforcement of awards and judgments. I'm head of enforcement for APAC, and our clients deal a lot with claims they already won, and they actually come to us not because they need funding on the merits, but actually they need the assistance with the enforcement. So I would like to share a little bit about that as well. And then I understand we will reserve the questions until the end. So then I'll hand over back to you, Jason. So first of all, that was the agenda. And there we go. The history and background of third-party funding. I think many assume that litigation funding is a practice that originates from Anglo-Saxon countries and actually from international arbitration matters, but actually funding of litigation by professional parties has been available for many years already in continental Europe, actually since the late 80s. And initially this pertained to debt collection against unwilling debtors in developing countries on behalf of, for example, credit export insurers or credit export agency. And Omni Bridgeway has been one of the first to actually provide this service since 1986, in fact. So then litigation funding subsequently further developed and was promoted by funders in Anglo-Saxon countries. Also, as Jan already just explained, I think also in a response to a need for international arbitration, which can indeed be very expensive. But who are these funders? Commercial funders are typically public companies or private companies or private funds. But most of the large litigation funders are actually directly or indirectly funded by institutional investors, as supervised by investment committees. And before deciding on funding a matter and a case will be presented and discussed with that investment committee. And for example, the investment committee of Omni Bridgeway comprises former judges, senior counsel, sitting arbitrators. So we don't go ahead and decide on funding lightly. So then, who are these parties that seek funding? Yes, of course, it's companies, multinationals, conglomerates, but also small and middle-sized entities, but also in-house counsel and financial controllers come to us. And actually the clients, the companies are of all sizes and across all industries, like energy and resource, export and commodity trading, but also transport and shipping, and so on. But also cases that and clients that come to us are actually insolvency practitioners when they are supervising a bankruptcy and they see that there are claims in there, but there's just no funds to actually proceed with the funding of that. They also reach out to us. Again, political risk and credit insurers, but also government entities and state-owned entities and also export credit agencies. But last but not least, there's also individuals, and it can be individuals by themselves or individuals that have a group, who have a group claim. It's not just arbitration that people are looking to have funded, but also commercial litigation. So then, why do parties want to use third-party funding? It was already said, it's not just parties who need the money, but it's also often parties who need expertise and help, including on the enforcement, about which I will talk a little bit later. Other clients indeed want to relieve pressure from their in-house resources or outsource the risk, or they just want to spend their money on running their business instead of spending that on legal fees. So how do we go about it? What are those criteria for funding? Indeed, there's one of the arguments, as I said, against third-party funding is that it may increase the number of frivolous claims. And I would like to briefly explain how this process actually goes. A funder does not likely take on a case, and before a claim gets funded, it undergoes actually a vigorous assessment process. And this funding decision is based on a number of considerations, including the good prospects of the case. So we look at the merits of the case, both factual and legal, and also on the jurisdictional and admissibility aspects of the claim. And second of all, a case needs to be economically viable. And that means that we always look at the proportionality between the realistic claim value, so the likely potential recovery, in comparison to the amount of funding that is actually being sought. So we want to avoid situations where the budget to the claim value is such that all or even a majority of the benefit of the recovery is going to flow mainly to the lawyers, the advisors, and the funder. So these claims have to be economically worthwhile for the client as well. And to achieve that, we typically look at cases that are, we can fund it when the quantum or the expenses that need to be invested is no more than 10% of the realistic claim value. And what do I mean with realistic claim value? That actually brings me to point 3, and that's the recoverability. Because what is also very relevant is the payment capability and the asset position of the respondent, of the counterparty. And also the likelihood that the respondent will actually voluntarily pay the claim. So if it is expected that for whatever reason the counterparty is not going to pay an award or a judgment, then there need to be realistic routes to recovery. So, and in that sense, the interest of the funder is completely aligned with that of the client, because usually funders do not get paid until there is a success. And success doesn't mean win the case, but success actually means payment, so money in the bank. So I think it is also good to understand that we reject actually a lot of cases. I think we fund maybe 1 out of 20 matters that are brought to us. And many of these cases are actually rejected because there just won't be enough for the client to recover in due course. So it may even be economically interested to the funder for us, but we don't think that it's commercially viable because there's just not enough left for the client if we proceed. So then I would like to speak briefly on enforcement, because that is one of the big a big chunk of the cases, I should say, that we fund. It's important that awards and judgment actually get paid. I mean, if clients go to litigation or arbitration for years, spend a lot of money, but in the end will not be able to recover their award and what is due to them, then all they have in their hands is a very expensive piece of paper. So basically, what we do also is really assess clients with that. And how do we do that? We always try to go for a strategy to create leverage on the counterparty, and always try to see how we can actually use various legal instruments in different jurisdictions to create that leverage. So of course, assets are key with that. So we have an in-house research team, we have an in-house asset trace team that actually looks at assets and looks at asset classes. So we try to identify bank accounts, but also money flows or hard assets like real estate, and see if we can actually enforce that and if they are based in enforcement-friendly jurisdictions. And we try to use their concerted efforts, and we try to understand, okay, what jurisdictions are those assets located, and how do we go about it? What's the applicable legal system? Is it possible to already have prejudgment attachment? Can you use the instrument of discovery? And we also look at prevailing doctrines, for example, on piercing the corporate veil, if it's possible there, and also the sovereign immunity doctrine. So if these assets that we identified, can you actually attach them and enforce on them? And yeah, how we do that before we actually commence proceedings or proceed with the enforcement. I think I would really like to impress on everybody that before you even start, ask yourself whether it might be possible or indeed likely that the counterparty is expected to evade payment for whatever reason, because if that's the case, it's good to have that strategy in place. Because like I said, let's try to avoid and come to a situation where you have a very expensive piece of paper. And I think for now, that's where I would like to thank the audience, and I'm really looking forward to your question and the discussion. Thank you.
Thanks, Marjolein. And we then move very quickly on to Catherine. Marjolein, could I ask you to stop sharing your... Thank you. Thanks very much. Catherine, you're muted.
Great, thank you. Good morning, good afternoon, good evening. Thank you to the organizers for sharing this event and to the two co-panelists. We had a very interesting discussion a few days ago, as already alluded to. I also want to build on some remarks I made yesterday that, as I understand, not everyone from yesterday's on was on today. I think the focus of this panel is a very important one, particularly in light of some things that both actually co-panelists mentioned. But for example, when John was talking about regulation and the advent of regulation, it was probably not lost on anyone in the audience that two of the leading institutions, in fact, the two first institutions ever to produce regulation on third-party funding are your neighbors in Singapore and in Hong Kong. And it's not actually an accident. The reasons for that is that, like Malaysia now, back in 2016 and earlier, Singapore and Malaysia had, Singapore and Hong Kong. You have to forgive me, it's 6 a.m. here in Italy, so, and my coffee hasn't quite kicked in. But in Singapore and Hong Kong, like in Malaysia, they had doctrines of champerty and maintenance that made third-party funding not only illegal in local litigation, but also, of course, in international arbitration. Why did they pass this legislation removing those doctrines' application to international arbitration? For some very important reasons regarding essentially a concern. One, that it's inevitable, because even though third-party funding might be illegal in these jurisdictions, it can still happen with regard to cases either seated in that jurisdiction. And I think Mario Line has an example of a case that was enforced in one of those jurisdictions, even before these measures permitting or removing the champerty and maintenance prohibitions. And so the idea is, well, to some extent, you're going to be affected and perhaps even have cases involving your jurisdiction involved with third-party funding, number one. But number two, the concern was that if third-party funders are funding, it depends on how you count, I suppose, but up to a couple hundred cases per year. And the cases that they're going to fund none of them are seated in your jurisdiction. Does it mean that you in Hong Kong or Singapore will have a disadvantage, right? Does it mean that the Hong Kong International Arbitration Center arbitrations will not be subject to or capable of getting funding? Will funders refuse to fund a case seated in Singapore because they think it won't be enforceable? So it was actually concerns about the potential competitive disadvantage that these jurisdictions and the institutions they've worked so hard to build, that in fact, I think at least in part prompted the regulation. That, again, in combination with the idea that in international arbitration, even strong national prohibitions don't necessarily completely preclude the possibility of third-party funding arbitrations under that law or being enforced in that jurisdiction. But they also, again, as John alluded to, were very smart in how they implemented this legislation. I ended up being involved because I was co-chair of the ICCA Queen Mary Task Force at the time. I visited with and had extensive discussions with both Singaporean and Hong Kong regulators at the time. And I think light touch regulation is a good way to explain it. The idea was mainly, one, to remove the prohibition against third-party funding with regard to champerty and maintenance. Most importantly, I would say these two mandated disclosure of the existence and the identity of the funder. Why these criteria? Number one, because they that was the number one concern with third-party funding not being disclosed, was that arbitrators can have a conflict of interest with a third-party funder. There are numerous scenarios under which that can occur. And if the presence and the identity of the funder is not disclosed, then the arbitrator does not have any way to assess whether there's a potential conflict of interest that should be disclosed. I want to emphasize here also two things. One, unlike conflicts of interest with counsel or with the party, in these situations, oftentimes, if there is such a conflict, when I say oftentimes, there actually are very, very few known situations that's come up. In fact, only one that's been truly published. But in that context, in that case, neither the law firm, nor the lawyer, nor the arbitrator, nor the party knew, as far as we know, of the conflict. Why? Because the participation of the party appointed, excuse me, still early here, still lacking caffeine, of the party, their party funder was known. So actually the only entity that was in a position to know about the conflict was the funder. Now, most funders, and I want to commend Omni Bridgeway as one of, again, they were on our task force, in part because they have a reputation for being one of the most, I would say, ethical, responsible funders. That's why we invited them on the task force. And so some of the leading third-party funders really do have internal standards and kind of self-regulation. But there's always one, that might not follow or might transgress in purpose or accident, right? So that's why rules are written for disclosure. But it's very important to have disclosure for the arbitrators to know and essentially assess any potential conflicts. As I said yesterday in my presentation, however, I actually think even without regulation, this can happen. And that is because arbitrators have a duty to investigate. And a very easy way to investigate whether there's a potential conflict of interest with a third-party funder you may not know is involved in the case is to ask, are there any third-party funders in the case? And then if the answer is yes, to ask for their identity. So I actually think even without regulation, that can be accomplished, should be accomplished by arbitrators. But they're in a very difficult situation. Co-arbitrators may be reluctant to ask. Some arbitrators feel pressure not to essentially offend third-party funders, and so to kind of play along lest they don't get picked as arbitrators in the next case that's getting funded. In addition, parties might object. Also, if it's unclear whether there has to be disclosure, voluntary disclosure, it can create tension between the funder and the party, because the party thinks, well, the IBA guidelines say I should disclose. And maybe a funder says, yeah, but it's not mandatory. We don't want disclosure. So one of the very valuable things of regulation is not just that it kind of makes a clear message about what should be done, but that it requires it. So it evens the playing field in a sense. Everyone's playing by the same rules. Everyone has the same expectations. So that's one really important value of regulation, in that it settles expectations and equalizes behavior. I'm going to comment just briefly on the light touch, which again, I think is very important and is challenging when you're writing this regulation. So if you look at our report, we have a number of recommendations, but we were very much along the light touch, meaning the primary focus should be on disclosure for the purposes of I would say, number one, arbitrator conflicts of interest. I also believe procedurally that parties have a right to know sort of with whom they're litigating. And so to the extent that they're litigating against another entity, behind that's in the shadows, I think that's, as a matter of procedural fairness, right for them to know. I would not, however, I generally don't endorse requiring disclosure of the terms of the funding agreement, which I know some responding parties that have to deal with funding and they find it frustrating, push for. The main reason why the terms of the funding agreement, the primary reason that's cited for terms being disclosed is with regard to a security for costs applications. Or concerns that the funding, for example, might cut off at a certain point and disrupt the proceedings, something like that. So usually it's about the sort of funding structure, the reliability of the funding, but also, and I think it's fair to raise, oftentimes also a strategic decision or effort by the responding party who's not very happy that the claimant they're responding to is, has significant funds. And so one thing that has been done, and this has been, I think, documented well, is that responding parties will, in a sense, seek disclosure of the entire agreement to increase the cost, to find ways to increase the cost, to disrupt the funding model. And that's not, I think, procedurally appropriate necessarily either. The bigger problem to me, however, with disclosure of the funding agreement is not whether you kind of side with respondents who want to have more information or kind of more of a light touch approach. It's really a question that I do believe in some funding agreements, attorney work product and attorney-client confidences can be embedded. Why? Because oftentimes the funding structure is tied into merits, expectations, strategy, decisions about the case. I think generally that would be inappropriate to essentially force one party to show the other party their cards in a game of poker, for a metaphor. So I think it's rarely appropriate to require disclosure of the entire agreement. Actually, I'm not sure if I would think that's ever appropriate, even unless heavily redacted. But there might be some provisions if there's genuine concern about ability to pay or other provisions. There can be other provisions that might be relevant. But generally speaking, when we talk about regulation, I think it's really important to keep your eye on the ball, which is number one, disclosure for the purposes of attorney conflicts of interest. And also to not forget that this is part of a marketplace. Singapore and Hong Kong were a watershed moment because many institutions were afraid to mandate disclosure at that time, back in 2014, 2015. And they took that move not only because they're great institutions and were brave, but because Hong Kong and Singapore as governments required them to. And so in that sense, the state change in regulation actually empowered the institution to make modern reforms that were really important to their competitive edge. So with that, I'm going to stop there and turn it back over to Professor Tra to continue his moderation.
Thanks, Professor Rogers. Thanks for that. And thank you to all three speakers for the very lucid and very succinct presentations, and all touching on very key and vital themes for today. So I think what I'd like to do now is to perhaps go back to a matter that was raised by both Marjolein and also by Jan, and that is the business model for funding. Because I think that when it comes to, say, a jurisdiction like Malaysia, trying to decide whether to regulate or how to regulate, a critical question has got to be how, I suppose it's about understanding how the business model works, because that then goes to the heart of what and who we are trying to regulate. So perhaps I could pose this question out there. So we are talking very much about a commercial decision based on what Jan and what Marjolein has mentioned. But on the other hand, when you go on to some of the websites of the funders, you will often see headlines about rule of law and access to justice and redress for the poor and so on. But to a certain extent, from what Marjolein has cited to us, that basically it's 1 in 20 matters which would be funded. And it also seems to me that empirical data suggests that the majority of cases which are funded are really commercial cases. I'm just curious about how, from our point of view, because the raison d'etre to me for these for the business model is access to justice. Now, how do you reconcile these two, to me, these two propositions? And one is we talk about access to justice, but actually the majority of cases that are funded at arbitration tend to be, investment disputes, tend to be large commercial claims, etc. So, but perhaps I might throw that open first to Marjolein, and then Jan, and then Catherine, if that's okay, in that order. Marjolein.
Yeah, thank you for that question. Yes, access to justice. Well, even the fact that many of the cases are rejected, that doesn't mean that we're just doing cases for large corporations or indeed the investment claims. There's actually a lot of cases that, and not just Omnibridge, but other funders also do, are, for example, IP claims where smaller businesses or universities who have intellectual property that's being infringed. And well, as many of you know, an IP arbitration or litigation can really be very expensive, especially in certain jurisdictions like the US and the UK. Can easily be 10 million pounds, something like that. And that is really for a claimant that just doesn't have the funds and also feels like, yeah, I mean, we cannot just let this sit, right? This is and that's the kind of cases that are also funded. At the same time, there's also several cases, group claims. For example, there's a huge GDPR privacy infringement case in Europe where a software provider gave protection or software to protect the computers, and actually at the same time we're completely monitoring what those users of that software were doing and selling that data to others. Well, you can imagine that if you're a consumer by yourself, you don't have the power and the money, and even it may not be worth your while financially at all to just start against this US software provider. But then if you're in a group, then actually you can. So that is also the kind of cases that are being funded. The thing is, and I think there was touched on in the panel before here, that of course usually there has to be a monetary upside there, because otherwise, yeah, I mean, we are investors, right? I mean, we need to make at some point money. Having said that, I also know that I and my colleagues, we have looked at cases before, and maybe the financials were less interesting, but the actual claim and the merits on it were interesting enough for us to also consider it. But of course, in the end and down the line, we need to, I mean, we need to be able to keep in business and also to make money, to also be able to invest and fund all the investments until the end. But I think there's certainly an amount of access to justice. Also think about bankruptcy cases where there are claims and where, for example, companies became bankrupt because of they were cheated out of a deal from a counterparty, or the directors and officers made a huge mistake or stole money or whatever. And yeah, I think that's quite clear that there is definitely that as well. So maybe I stop there, and Jan would like to hear what you also think.
Yes, Jan, just go ahead.
Thank you very much. Thank you, Jason. And I think I agree with what Marilyn said. And it is true that, first of all, whether you want access to justice or you don't want access to justice, if you fund some cases, this will be the result for those funded parties. Because if they cannot bring the case eventually without the fund, they will be able to bring their cases. So this will be the result. However, as Marilyn said, that the funders are not in that business only to provide the access to justice. They are in this business to make profit. So this is, again, I think, the balance is always the important question in many issues. And here is that as well. Funders have obligations to their investors. And of course, funders have obligations once they agree to fund a case. So in that case, that I know some funders actually are doing even bona fide, very minority bona fide funding as well. But investors need to agree with that decision as well. So the result, I think, definitely it will increase. So that more people will have the access, because you can have an amazing system, mechanism to resolve disputes, litigation, arbitration. But if people or companies cannot access it, there's no use. So funding is definitely helping to that purpose, because more claims can come to the surface. And in that case, I see that as a positive development. But again, some minor funders can behave badly, and this can create bad examples in the market, and that's why there needs to be a kind of mechanism to prevent such behaviors in the market as well. But in general, I would say that definitely it will increase the access to justice. Whether this is your purpose or not, this will be the result of funders operating in the market. And I think I will stop here as well and let Catherine move on. Thank you.
Catherine,
So
please just jump in.
It is more of a practical question, so I'm going to leave them with most of the last word. I will just say one of the most frequently raised complaints about international arbitration is actually the cost. And here I'm going to pause with maybe a slightly different take on funding, in that it not only can provide, and it's very important, obviously, that it provide for certain users like small and medium-sized businesses that for which the cost of arbitration really can be prohibitive in pursuing even very legitimate claims. So it's and that is clearly problematic for the continued thriving and contributions of small and medium-sized enterprises to the global economy. One thing I will mention, which I describe in my book, and I think it's an important thing to consider, third-party funding, oftentimes the contracts are sort of triangular in the sense that they involve the law firm. And one of the biggest sources of costs in international arbitration is actually not the cost of the arbitrator or the institution, but the law firms. And because of the historic, and this is a sort of critique of the legal profession generally, the use of the billable hour, there's oftentimes observed that lawyers have an incentive that cannot be, sometimes not well aligned with that of the client, which is to save as much money as possible. Whereas the lawyers, of course, again, their compensation is tied to how many hours they work. So there's sort of a tension between those two. And third-party funders can, and I think it's been demonstrated effectively, rein in some of the potential excesses of law firms that might overbill, not overbill in the sense of unethically overbill, but for example, just get a little more ambitious in pursuing the claim that might be considered from a more independent perspective actually necessary. And so one of the positive things that funders do is they set up a clear budget, which can be very helpful to the client, because clients sometimes are not very good at monitoring outside law firms. They also tie rewards sometimes, depending on the contract, to certain kind of, I'll say, balance between outcomes and cost savings by the law firm, which again is a very positive thing, not only for the individual client, but for the costs in international arbitration. So there are some positive things in terms of monitoring that third-party funders do. And the last, I'll touch on what Mario Line said earlier, which is the fact that they are, for the most part, and I will say it's not impossible that certain claims, especially with very, very high dollar amounts, might be less well-founded and get funded. But the fact that they actually aren't funding 19 out of 20 claims provides a sort of screening mechanism, I think, ideally, when it works. And that is that the good claims get funded and the less worthy claims don't. The problem is, as Jan started earlier, is we have a lot of funders on the market. I would also like to highlight that it's not only commercial funders that fund cases. It can be, for example, disgruntled parties who, want to, who find someone, they can't afford their own lawsuit. The very famous one, I have never watched it in my life, but World Wrestling, there was I think Hulk Hogan, who was a kind of exotic celebrity in the United States, had a defamation claim, and he was funded by a very wealthy individual who had a grudge against the media outlet that had allegedly defamed him. And that is a type of third-party funding. It's not professional third-party funding. To be honest, it's almost impossible to regulate effectively because it can happen behind the scenes. But that can also be very pernicious. The kind of professional third-party funding that we're seeing mostly in international arbitration, on the other hand, I'll just end with the idea it also has some positive benefits, not only for the clients, but also for the regime in keeping its costs under control.
Thanks, Catherine. Thanks very much for that. So A follow-up question, I suppose, based on the business model, has got to be a regulatory system that matches, if you like, the market imperatives. And of course, also policy issues such as professional responsibility, access to justice, ethics, and so on. And so I've been looking at the European Union proposals for regulation, and I wonder whether you would care to comment on whether you think that that regulatory approach is light touch, or do you think it's too heavy touch, and that it is perhaps removed from reality, given the state of the vibrancy in the marketplace for funders and for arbitration. So that's one point, because for obvious reasons, if you compare the EU approach to, say, Singapore and to Hong Kong, it's quite obvious that the EU is a little bit more interventionist, for example, requiring that, you can only find up to, you can only recover 40% of the maximum compensation, and that there is also to be imposed a fiduciary duty. There is also requirements for adequate capital, so that, as Jean was talking about, there's this risk of discontinuation of arbitrations. So at one level, from a consumer's point of view, the EU regulation seems to be much more proactive. So I wonder whether you could comment on that. And I would just cast in an ancillary question since I've got the floor now. And the second question is really this. The EU approach, as well as the Hong Kong and the Singapore approaches, really are concerned largely with regulating the funders. But from what Catherine was talking about, I mean, obviously arbitrators have a duty as well. Also, she mentioned the fact that it is entirely open to the arbitrator, subject to the various constraints she alluded to ask whether there is, third-party arbitration funding at the background, and also even to ask to see the agreement itself. And then, of course, we also heard from Marjolein and also from Jean that lawyers are, of course, involved. And, of course, they also owe a sense of professional responsibility. And so to me, perhaps the question is that, are we perhaps missing the focus by thinking or talking about regulating the funders and not regulating the industry per se? So those two questions, to recap, the first question is, what do you think about the EU approach to regulating third-party arbitration and litigation funding? And the second question is really about, do we regulate the industry broadly construed, or do we regulate the funders? Thank you. So I will ask Catherine to go first, and then this time perhaps Marjolein, you could go last, and then Jean, you go second. And I won't pause, I won't come in to interject, just move from one person to the other, because time is not on our side. Catherine.
Okay, I guess we have short time, and I think actually it's going to be very interesting to hear what Marjolein, who's probably studied it more carefully than me, thinks about the new regulation. A couple things. One, I think that there have been issues, and there should be an attention to the relationship between funders and lawyers. One of the interesting questions I have is, in the United States, it would be if you provide legal advice or do various activities, it's considered the practice of law. The funding agreements all say very clearly they are not providing legal advice, they are not practicing law, but what determines whether you are engaged in the practice of law is not whether you say it or not, it's whether it's what you do. And if you are strategically assessing cases, if you are approving the use of certain expert witnesses, it seems to me that you are engaged under US definitions, which are stricter than many other jurisdictions, in the practice of law. What does that mean? It means, I believe, that funders should be subject to a number of rules that are, as a professional matter, tied to their lawyers. One of them, for example, is with regard to confidentiality and conflicts of interest. So funders get tons of important confidential information when they're trying to assess a case, but especially if they do not take on that client as that party as a client, they have absolutely no ethical responsibilities provided at an industry level, right? With what they do with that confidential information, how they might use it, what if the opposing party comes to them for funding, right? So which the law firm would be prohibited from even entertaining a question about, right? But funders are not. Now, an easy way to fix that is some rules that do exist already in the United States, which is when you have, even if they're accountants, if they're nurses, whatever, and they're working with law firms, essentially affiliating with law firms, they just agree to abide essentially by some of the same rules, particularly with regard to confidentiality, conflicts of interest. I do think that there is, when I said regulating in light touch and all that's required is disclosure, I was really looking at international arbitration, not the market for funders. I don't know, I'm not in a position to talk about that 40% cap. I do think that they're, they are very analogous to insurance. Insurance is an incredibly highly regulated industry. So the idea that there would be some regulation, and in fact, some funders are providing what is either actually insurance, like before the event or after the event insurance, or highly analogous to insurance. So the idea that you would regulate the industry, to me, does not strike me as, some radical problem. The challenge, I think, is, and it's going to sound a little academic for everyone, but is defining what you're trying to regulate, right? So we know when we have Omni Bridgeway here, we know what we think we know what a third-party funder looks like, but a third-party funder can take on numerous different forms. If you have a special purpose vehicle, for example, that creates a different, regulating a different entity than the actual funder. If you have portfolio funding where the funder provides funds to a law firm, totally different regulatory framework. It evades many of the existing definitions, and I think would evade a lot of the regulations that are out there. So I think any regulation of third-party funding, which is what both Singapore and Hong Kong did, also includes some revision or reconsideration of also lawyer regulation. And I think with regard, again, I'll defer, but the idea that we would regulate the market for funding, I don't think is at all out of bounds or inconsistent with, restrained, right? I don't know, it's regulation gone amok just because the EU is considering regulating the market. Again, insurance forever has been a very highly regulated field.
Thank you very much. I will try to keep it short as well, because as Catherine said that Marilyn probably analyzed the European Union regulation much closer than us. But I also agree with Catherine what she said. I think it is definitely requiring a lot of considerations. It is not an easy job. That's why I think it needs some time, and it needs involvement of many relevant parties, including lawyers, funders, arbitrators, experts, maybe insurers, like really a wide platform that so everyone can put their input. So in that sense, as long as they are doing this, I think it is a good trend that we are regulating in a controlled way, that everyone have a say and nobody is basically negatively affected. Because one negative potential, actually, if you regulate the market and if you regulate heavily, then this will really decrease the number of potential funders. Only funders who have large capital can basically operate easily, but the small funders cannot survive if you impose high regulations and compliance duties to everyone in the same way. So it is really, again, an important balance between these two. So I think it would be sensible to regulate, but not too hastily, and then involving all the stakeholders in the field. And in that sense, for the second part of whether regulating only the funding or the industry as a general, I think exactly that's a very, very important question, because there were some posts that you also saw that maybe the barbers have more regulations than arbitrators that to comply with. Like this is really unregulated market. We have a lot of guidelines, and we have really good examples, and we have unfortunately bad examples as well. So in that sense, you would have the same approach. I always tell my students in my class that if you have good arbitrator, then you have the best dispute resolution mechanism. But if you have bad arbitrators, then this is the worst dispute resolution mechanism you can ever stuck into. So it is really depending on how and who you are dealing with. And I think when it comes to funders, it is the same issue, that if you are dealing with the good funders that are already regulating themselves without the need that there is a document that they should look at, then it is operating very well. But if not, then there will be some problems. So that I think all the stakeholders should come together before making any regulation. That would be my point. Thank you very much.
Sorry. Yes. Yeah. I think, first of all, I'm not against regulation, right? I think it makes sense, and I think it was you, Catherine, who said before that, you know, if there are some bad parties out there, it also make all the funders look very bad. So I think that it makes sense to do that, and that you want to make sure that people who actually want the access to justice or need the funding actually get where they end, and also get to the result in the end. So that, for example, if you say funders need to have capital requirements because they need to be able to fund the case and to really see it through until the end, I'm for that, obviously, and I think everybody would be, because that makes total sense. The problem, no, not the problem, but the issue that I have with what's the discussion that's going on in the EU now is some of the issues or some of the solutions that are put in there or suggested in the regulations now. I'm not so sure if they actually solve a problem. More specifically, sometimes I'm under the impression that it's not really clear if there is an actual problem or whether it's more an academic problem. And that is just something, I mean, I think, yes, we all agree you need to, if you start funding, you need to end it. If you are conflicted, of course you shouldn't do it. You cannot take on a case that you studied before for the claimant and you're not now going to do it for the respondent. I think we're all in agreement with that. And I don't object to that. And I'm pretty sure that, you know, the funders don't object to that. It's just that sometimes the discussion is a little bit, it can go too far. You try to regulate too much. And I like to, and that is something I think it would be good to really understand which is the problem and what do you want to solve. For example, the cap that's been set, funders should not get more than 40%. 40% is a lot of money if you're talking about a claim of $50 million, right? But if you're talking about a claim that's $1 million and people still want to do it, then it may look actually very different, because you all understand if you're going to do a case and the claim is $100,000 and you have to spend, I don't know, $1 million to do it, it's not even commercially viable. But there are also cases where you can say, well, it's a lower claim amount. It's still commercially viable because the enforcement actions, for example, need to take place in affordable jurisdictions. But it may also mean that if a funder still needs to invest, I don't know, $200,000, that they may get a little bit more, no, that the client gets a little bit less than 60% of the claim, just because of the costs of getting that title in, and even make it worthwhile for the funder to invest in it. So I think if you impose that cap, you actually throw out a lot of smaller cases that just may not be more viable to actually pursue. And I also think it's a little bit condescending to the claimants who are actually looking for funders, because many of them are very sophisticated buyers. They are represented by their law firms, they are in-house counsel, they know what they do, and it's just a negotiated contract. And just to say, well, they don't know what they're doing. I'm like, I don't think there's a one-size-fits-all. Another problem with the cap is also, if a respondent knows about that cap, and they also know what the claim value is, and they also know what the likely investment is, they can actually, you know, make it very expensive and just cause a lot of incidents and in litigation and fight, just knowing that they put actually the case out of business just because they know, oh, a funder can never spend more than this amount, so that makes, you know, this claim go away, because if I just fight a little bit hard enough, then it's not going to be pursued. So that's why I'm like, I get it that it should be fair and that you should, but as I said before, we're always looking at cases that are economically viable, not just for us, but for everyone. I think that's a fair thing to do. And I think that you should put in one way or the other, but just put a number on it that everybody knows that actually may cause more issues. And then I'm like, I'm not sure if that actually solves the problem that it seeks to solve. So anyway, I think there's a lot of things in that regulation that obviously there's pros and cons. So maybe let me move on to the second question, like, do we regulate the industry or the funders? Again, I think it's not unfair to say there need to be regulations. You can hold funders up to certain standards. I don't think we are actually in the legal business, even though many of us are lawyers. I don't give legal advice, even though I sometimes give strategic advice on enforcement, but it's always based on advice from local counsel. Having said that, yes, we have conflict check in place. We enter into confidentiality agreements with our clients, which also means that whatever we get, we can't use. So it will be just a breach of contract or tortious if we actually then decide to use that information later on for whatever. I mean, that's not an unfair ask, I think, to ask that for funders and anybody who is actually a professional assisting a client. That goes for the experts, that goes for the quantum experts, that goes for whoever you're going, your auditors and everybody else. So yeah, I think that's a fair thing to say.
Thanks, thanks, Marjolein. Okay, so we come now to the questions which have been posted on the Q&A. There are 6 questions, but we will not have time to deal with all of them. So there are some individuals who have asked 2 questions. I would take moderators' prerogative and pick one. So the first one comes from Samuel, and he says, this question is for Marjolein. If you could just be very brief, Marjolein. In a scam case where there is no willingness to pay, how would this be assessed for funding? So I presume the question is, if in a situation where really perhaps there is no sense of recovery, how would this be assessed? I think you mentioned recoverability earlier on.
Yeah.
Perhaps you might want to touch on that.
Yeah, very briefly. Well, if it's a scam case, I suppose it's meant that there's already an award or judgment, and the respondent is not paying because they think it's a scam case. So that's why we think it's totally unfair and not paying. We always look at what is the award, what does it say? Of course, also what were the arguments from the respondent, and if there are any allegation that we indeed think, oh, but that's a scam case, obviously, then we're not going to fund it because it's not a good case on the merits. Also, I think it is, yeah, I doubt it would be funded at all. And even, yeah, so look at why a counterparty isn't paying. And if we think it's not because it's just an unfair case, then we will not proceed. I think in my experience, the cases where counterparties don't pay is usually either they don't have the money. I mean, then of course they can't pay, so they won't pay, or they can get away with it. And of course, there's always objections and things that are raised, but we will really explore that. Why do they say they're not going to pay? And if we indeed think that's a scam, then it's not going to be funded. That's, yeah.
Okay, thanks, Marjolein. So there's a question from Jorge. I would perhaps, he asks, what are some of the most common misconduct actions by third-party funders? I think we will pass on with this question because I think Jean's slide addresses this very well earlier on. And there was another question by Samuel, which we will have got to also bypass. And then there's a question from Yuan Chuan Lee. And she asks, is it really correct to say funders are not regulated on giving advice? Do not funders have in-house lawyers and are thus regulated? Catherine, perhaps over to you.
So I think when you talk about the role of an in-house lawyer or funder, you're talking about their role with regard to advising the entity and how it behaves, which is different than advising activities in an individual case, right? I don't think an in-house counsel for funders, I don't think are involved. They're not designed to be involved in every single case. That's not the role of an in-house counsel generally. So first of all, I will underscore what I think Marjolein has already suggested, which is some of what we would call ethical regulation is captured in funding agreements. So to the extent that funders voluntarily say, you know, as a contractual matter, we will not use your information, you know, in a way that's contrary to your interests. My concern is that sometimes those are defined differently in contracts than they might be for professional regulations. And that it's good to have the lawyers' standards for what constitutes a conflict of interest or what constitutes proper maintenance of confidential attorney-client confidence consistent with other professionals who are working with those attorneys. So it's not really a question of, you know, reining in, you know, supposed misconduct by third-party funders, but aligning the conduct. So also because it can, I think, create some tensions. One which maybe harkens back to what is the most, you know, the misconduct we see. I actually think one of the biggest issues that's a bit of a sleeper is actually the lawyers, not the funders. I think that anytime a lawyer is being compensated by someone other than the party, there's a tension, right? There's a pull, a tug on their loyalties. And I think that's why it's really important for, and this goes to another point that Marjolein made, for lawyers who are receiving, depending on the contract, funds directly from the funder to encourage their clients to get independent legal advice about entering into that contract, or to, in jurisdictions where that's not legally required or ethically required, to do their best to give, you know, independent legal advice before accepting the funder's terms. It can be difficult, but it is something that needs to be addressed up front. There have been lawsuits by clients upset with their lawyers for not properly advising them on the terms of the funding agreement. For example, on the threshold, the 40% threshold, we can imagine, for example, that, you know, parties should be able to accept a settlement for 20 cents on the dollar, because that is more than they could, you know, that's better than nothing is the kind of argument. But before they get a settlement, right, they get independent advice from their lawyers about, you know, what is their likelihood of success, what's going to happen to their claim if they don't accept the settlement. And so as long as the clients, and I would put aside consumers in this one, but as long as you have a sophisticated commercial entity that's thinking of entering into a funding agreement, if they have appropriate independent legal counsel, you know, that does a lot to counterbalance that threshold that the EU appears to be considering. And the other point is that threshold and how it's even calculated depends a lot on the nature of the funding agreement. You know, what you can assign a claim, right? A party could sell in many jurisdictions, right? Can assign their claim to another party for some fraction that's probably a lot less than 60%. So I think it's I understand the impetus behind it and the concerns behind it, right? The funders shouldn't be the ones, you know, making most of the money. It should be the claim holders. But I think it's a little bit flat and perhaps overly simplistic for the complexities of this market.
Thank you. Thanks, Catherine. Time is up, but I thought maybe we could give the last word to Jean, who started off. And this perhaps refers remotely, indirectly to Vishnu Menon's question. And really, it is about if an arbitrator wants to do good vis-a-vis a third-party funding agreement, but the institutional rules may not allow them to do so, how would you advise that arbitrator, John? And please keep this to just less than a minute, and then we will wrap things up.
Thank you very much, Jason. Then very briefly, since our time is up, then I think if there's no institutional rule, arbitration tribunals or arbitrators would basically give an order, procedural order, to make the disclosure mandatory in their arbitration, to do their necessary check. But then the question, what they need to disclose, the similar questions, I think identity of the funders involved, the names. I think that will be important, not too much detailed disclosure. I think a procedural order would help them to solve this issue. And since I'm the last one, and I would like to thank you, Jason, and the organizers for having us as well. And I hope that answers the question. Thank you very much.
Well, thank you. Thanks, everyone. And the final word then, of course, other than thanking our panel speakers and the organizers, is to thank the audience and the participants for your very constructive questions and interest in the subject. So thanks, everyone, and have a really good evening, good day, good afternoon, good morning. Okay, thanks, everyone. Thank you. Bye-bye.
Thank you.
Thank you to our panel of speakers and moderator for this insightful session. Ladies and gentlemen, we have now come to the end of today's conference. Thank you for your support and participation in this event. On behalf of the AIAC, we would like to thank once again our collaborating partner, the Legal Affairs Division of the Prime Minister's Department, Malaysia, and our supporting organizations, the Inns of Court Malaysia, the Malaysian Institute of Arbitrators, the Chartered Institute of Arbitrators Malaysia branch, and the Borneo International Center for Arbitration and Mediation for their continuous support. The AIAC extends our sincere appreciation to our esteemed moderators and panelists for making this KL webinar a resounding success. And to all participants, we look forward to hosting you all at future events at the AIAC. Thank you all.